The impugned revised official memorandum dated 12/10/2021 has been issued by the Deputy Commissioner, once again reserving 5 acres and 4 guntas of land in survey number 21 of Dharmapura village. For the purpose of Kasai Khane ilva? For the purpose of public burial ground. Next para. There shall be an ad interim order of stay of the operation and execution of the impugned revised official memorandum dated 12/10/2021 at Annexure T until further order. Next para. The respondent Deputy Commissioner is required to file an affidavit before this court before the next date of hearing, answering as to why no orders have been passed in spite of specific directions being given by this court in its order dated 11/6/2018 in WP number so and so. Full stop. Release this matter on 24th of February.
Number 2, Mama Tayuriye. Number 2. Postponement of elections. 19/2022.
The same order. ಯಾವ ಒಂದು ಸರ್ಕಲ್ ಇಶ್ಯೂ ಯಾಕೆ ಎಷ್ಟೊತ್ತು ಬೇಕ್ರಿ ಅದಕ್ಕೆ? Learned AGA takes notice for all the respondents. Sorry. Takes notice for response. Same, same. Respondents, sir. Learned the AGA takes notice for response number 1, 1, 3, and 4. 1, 3, and 4. Learned Council Shri TL Kiran Kumar is directed to take notice for response number 2 and 5. No notice to response number 6 is dispensed. Similar order. Pass over agadilla. There is no time. I will just issue notice aste. Ready.
The land was mentioned this. The land was reserved the persons who are lost their land to be able to reserve project. So the land was reserved in the year of 1971 under the section 71 of the Kerala Act. The very purpose. In the year of 1978, the land was granted to the petitioner. Thereafter, in the year of 1994, the Akri Assam Taluku has granted the land.
These private respondents are persons who have filed applications for regularization.
Other respondent number 6 to 62 are the grantors under the Assam Settlement Committee.
ಅದನ್ನೇ They have filed application
Please.
seeking regularization.
Please.
Similar, which is that application? What directions have you given? ಇಲ್ಲ ಇಲ್ಲ ಬಂದಿದೆ ಇನ್ನೊಂದು ಬಂದಿದೆ.
My lordship.
Of course, we have not disposed of the matter. Yes. Huh? Correct. The other side respondents are claiming that they have filed application for consideration of their application for regularization. So there are rival claims.
Thereafter, after granting the affirmative.
What is the order that you are challenging?
Annexure A, my lordship. The order passed by the R1, Deputy Commissioner, Rajasthan District. So,
ಏನಂತ?
the order of the year of 1978 granted order in favor of petitioner under the distressed person. That order is set aside and upheld the order of the affirmative committee in year of 1994. Land is very purpose for reserved for purpose of the grant of the displaced person. This number one petitioner is the displaced person, my lordship. So thereafter the petitioner has challenged.
Similar repetition is there. You have passed some orders.
Yeah, my lordship. See, earlier.
Whether there was a genuine grant. ಇದೇ ತರ.
Rehabilitation that is different aspect. Otherly, the revenge of the land holders was under consideration before that committee. But here, the land particular land is reserved from the allotment of displaced persons. Other persons were not land holders of the aim of the project. They have filed application.
That is for regularization.
Other I should do. We have lost the land.
ಇದೇ ತರ ಇತ್ತು ಇನ್ನೊಂದು. ಒಂದರಲ್ಲಿ ಅಲಾಟ್ಮೆಂಟ್ ಇಸ್ ಮೇಡ್ ಟು APMC. ಇನ್ನೊಂದರಲ್ಲಿ ಸಿಮಿಲರ್ ಟೈಪ್ ವೇರ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಆರ್ ಫೈಲ್ಡ್ ಅಟ್ ದಿ ಹ್ಯಾಂಡ್ಸ್ ಆಫ್ ಅದರ್ ಪರ್ಸನ್ ಕ್ಲೈಮಿಂಗ್ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಆಫ್ ದರ್ ಅನ್ಆಥರೈಸ್ಡ್ ಅಪ್ಲಿಕೇಶನ್. ಎರಡು ತರದ್ದು ಇದೆ. ಎನಿವೆ, takes notice for response number
They are trying to eliminate the property.
1 to 5. Issue notice to response number 6 to 62. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. The impugned order dated 7/10/2021 has been passed by the respondent deputy commissioner, setting aside orders of grant made in the year 1994-95 in favor of the petitioner and other similarly placed persons who were granted lands for resettlement on account of the petitioner and other persons losing their lands or being displaced for Hemavati Reservoir project. There shall be an identity mode of stay of the operation and execution of the impugned order dated 7/10/2021 passed by the first respondent deputy commissioner, until further order.
The date wrong. 19/5/1978. 19/5/1978 is a grant order of the petitioner.
78.
78. Operative portion of the annexure in the 19/5/1970.
ಎಲ್ಲರಿಗೂ ಒಂದೇ ದಿವಸ ಗ್ರಾಂಟ್ ಆಗಿರೋದ?
ಪಿಟಿಷನರಿಗೆ along with 4 members ಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ 19/5/1970.
ಅಲ್ರಿ, ಇಲ್ಲಿ you come, please come to page number 23, first page of that order. You are the Allah Dasegowda.
Please, madam, please, madam.
You are the appellant there, is it?
Yes, please, your honor.
You are the appellant.
Please, please, madam.
You had challenged the order of the assistant commissioner.
Please, please, madam. It was granted to me in the year 1978.
And you have not sought for interim stay of the order of the assistant commissioner?
Here, the assistant commissioner passing the order on the RA 35. That is also aware of passing that order also.
Interim relief ಇದೆ.
Interim relief ಅಲ್ಲಿ R1 order ಮಾತ್ರ ನಾವು ಕೇಳಿದ್ವಿ.
Okay.
Because of AC order, which is finalized, then we have filed appeal before. the
AC order was also against you.
ಅದು only part your honor. My notice there.
Anyway, you don't,
Mutation
sorry, if you don't want any interim relief, that is all right. Adರಲ್ಲಿ land granted to the petitioner in the year on 19/5/1978. ಅವಾಗಲೇ 1994-95 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು land granted to the petitioner on 19/5/1978. Yes.
Number 4.
For the petitioners in this case, Lord. Petitioners are
Yes.
the agricultural tenants, Lord. The predecessor of the petitioner, Lord, was the agricultural tenant who was cultivating the lands in question, Lord, under the ownership of third respondent temple committee. Lord, his name was appearing in the RTC since right from the year 1960-61. Annexure C I have produced to show that his name was appearing. Subsequently, my lord, as on the date of vesting, 1/3/1974, also, Lord, the name of the petitioner's predecessor were appearing as tenant, and the mode of cultivation was shown as number 5, which is not tenanted by crop share.
Is this the second round of litigation?
My lord, it is a second round of litigation.
What happened earlier when you had come before this court?
Lord, earlier, my lord, the land tribunal conferred the occupancy right that was challenged by the third respondent before the sum court. That writ petition was allowed and remanded. Subsequently, my lord, the tribunal has rejected.
Remanded for what purpose?
My lord, for fresh consideration of the application.
Please take me to that order.
Yes. My lord, that order has not been produced, my lord. That is not available as on today, my lord, because it is very old order, 1977. I could not get it, my lord. I will secure the certified copy and place it on record, my lord.
Because
Please,
we have to see
please.
for what purpose it was remanded.
Lord, it was remanded for the purpose of reconsideration. The
There
third
would be,
of-
sir, there would be some observations.
Yes, yes. I will place it on
You
record.
don't want to produce those documents, then what is the use then?
My lord, I
You
could
will have
not
to see
get-
whether
Yes,
the directions issued by this court have been followed by the land tribunal.
my lord. Subsequently, one more order passed by this on the court at the instance of the third respondent.
Order is quashed.
Elide Torsi, please show it. Please show it, sir.
My lord, I will place it on record, my lord. Thank
No,
you.
I can't understand why you are shying away from producing those important documents.
My lord, it was of the year 1977. I could not secure the same from the party.
Learned AGA takes notice for response number 1 and 2. Issue emergent notice to respond number 3.
Lord,
Yes.
entries, my lord, are standing in the name of the petitioner.
No, let us see, let us see.
Delete
Yes.
GS.
My lord, may I
Yes.
seek one intelligence, my lord?
When was the order passed?
My lord, December 2021, my lord.
Huh?
December 2021, my lord. Annexure A, my lord. 21/12/2021. My lord, the order is not signed by all the members, my lord. Annexure A, page number 30, my lord. Only 3 members have signed, my lord.
Writ petition allowed Akriti. Allowed, see the order quashed. After giving opportunity to the stakeholders, again ಬೇಕಾದನ್ನು ಮಾಡಿ. I'll
Order dated 21/12/2021 at annexure A till the next date of hearing.
Apply, my lord.
Number 6.
Yes.
Not the petitioner's grievance is that my lord, long back, my lord, the annexure A, as per annexure A, Khata has been made out in his name, my lord, in the inheritance proceedings, my lord. My lord, thereafterwards, my lord, the contesting respondents, they approached the respondent state commissioner subsequently, that is in the year 2015, annexure E, and my lord, matter was remanded.
What is annexure A?
Annexure A is IHC proceedings, my lord. Typed copy is at annexure page 20.
IHC dated?
My lord, that is in the year 2001, it has been taken up, my lord. Date is not properly mentioned. But this is IHC proceedings 2000-2001, my lord, 28 for 2000-2001, my lord. Then, my lord, the Khata has been made out in his name. My lord, the typed copy is at page 20. My lord, ಲಾಸ್ಟ್ ಅಂತ ನಾವು ನೋಡೋದು ಅರ್ಜಿದಾರರೇ ಅನುಭವದಾರರಾಗಿರುತ್ತಾರೆ, ಅಣ್ಣ ತಮ್ಮಂದಿರುಗಳ ಒಪ್ಪಿಗೆ ಇರುತ್ತೆ. ದಿಸ್ ವಾಸ್ ಎಫೆಕ್ಟೆಡ್ ಮೈ ಲಾರ್ಡ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದೀಸ್ ಸರ್ವೆ ನಂಬರ್ಸ್. Then, my lord, annexure E, my lord, after a long page number 38 may kindly period. After a long lapse of time, my lord, in the year 2014-15, one of the contesting respondents, one Lakshmama, challenged this order, saying that she is also entitled for a share in the property, and Khata should not have been exclusively made out in my name. But matter was remanded by the assistant commissioner to the Tahsildar. My lord, annexure B is the impugned order, my lord. According to this order, my lord, the page 24 may kindly be perused. There, my lord, the Tahsildar directed the authorities to make out the Khata in the name of all the persons, that is Badi and respondents number 2 and 3, who are the family members. My lord, appeal filed by me has been rejected, and my lord, deputy commissioner revision is also rejected. My actual submission is this, my lord. At an undisputed point of time, there was an acceptance with regard to the change of Khata, and there was a partition of the property, my lord.
Who is this Lakshmama?
Lakshmama is related to the father of the petitioner here in Meerut. She is the daughter-in-law from Gangaya, who is the uncle of the petitioner Raman. She says she is having a right. My prayer is, suppose, my lord, if the revenue authorities, my lord, should not have unsettled the settled entries, directing them to approach the civil court if they are entitled for a share. Instead of that, my lord, they have directed them to approach the civil court. And there, my lord, I humbly pray the honorable court's consideration of my prayer. If that is the case, my lord, let them file, my lord, partitions, call out their shares. But settled matter should not have been disturbed. This is my anxious submission.
Learned AGA takes notice for response number 1 to 3. Issue notice to respondent number 4 to 6.
Yes, sir.
Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA.
Please.
Next para. Learned counsel for the petitioner submits that during the year 2000-2001, in a proceedings before the respondent Tahsildar,
Please.
Deputy Tahsildar, the name of the petitioner was entered in the land revenue records in respect of the land in question. Consequent to the statements given by the brothers of the petitioner, stating that in a partition between the members of the family, the lands in question have fallen to the share of the petitioner. Full stop. Accordingly, the name of the petitioner was entered in the land record. Full stop. Learned counsel submits that nearly 13-14 years after the name of the petitioner was entered in the land revenue records, at the instance of the fourth respondent, Srimati Lakshmama, the respondent Tahsildar passed the impugned order dated 29/5/2015, directing entry of the names of respondent number 4 along with the petitioner and other members of the family in the land revenue records. Stop. The appeal and revision filed by the petitioner before the assistant commissioner and deputy commissioner was unsuccessful. Full stop. Learned Council submits that the authorities were not right in accepting the contention of the fourth respondent to enter her name in the revenue records. Since at an undisputed point of time, the name of the petitioner was entered in the land revenue records. So, therefore, the authorities should have directed the fourth respondent to secure a decree or declaration at the hands of a competent civil court. Full stop. Next para. There shall be an ad interim order of stay of the operation and execution of the impugned orders at annexures D, C, and D. B, C, and D. Please. Come on, till the next date of hearing.
My lords, I appear for the petitioner, my lord.
Yes.
My lords, the petitioner is challenging the impugned order, my lord, passed by the respondent at annexure A, my lords, that is the endorsement, my lords, issued on 26/8/2021, my lord. My lords, the case of the petitioner is that, my lords, the petitioners have filed a Telecast application in the year 1973, my lord, in survey number 18 of Urulhalli village.
Application for
Telecast application, my lords.
Telecast.
Yes, my lord. That has been the, my lords, in the year
Telecast application then.
My lords, for unauthorized occupation of they were in the occupation of the unauthorized occupation.
Seeking regularization of unauthorized occupation.
Yes, my lord. Regulation of the occupation of the land. Subsequently, my lord, that has not been considered. The petitioners herein have preferred a writ petition, my lords, in WP number 7707 to 7711 of 2019. And I have produced the order copy, my lords, at annexure P, my lords, page number 57. And they have also given this honorable court, my lords, has passed an order. See, my lords, a direction has been issued to the respondent Tahsildar to consider their applications, my lord. Subsequently, my lords, in view of not considering the applications, my lord, not considering the representation, I have preferred a contempt petition, my lords, in contempt number 439 of 2021. My lord, that has been dropped, my lord, by giving this annexure A endorsement, my lords, at page number 14, my lord. My lord, may I permit to read that annexure A, my lord? Page number 15, my lord.
ಲಭ್ಯವಿಲ್ಲದ್ರಿಂದ ಅಂದ್ರೆ ವೈ ಹಿಂದೆನೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಂತಲ್ರಿ 1985 ಅಲ್ಲೇ.
That's the case of the petition is that, my lord, in same survey number, my lords, one Lakshmesh, my lords, have granted the land, my lords, to the extent of 4.38 acres. My lords, as per the index of land, my lord, it's annexure N, my lord. Annexure N, my lord.
Allah, the problem is your application was rejected way back in the year 1985.
My lord, in as per annexure N, my lord, the memorandum.
Adanna, you will say it was not communicated to you.
Yes, my lord. My lord,
Alva?
as per annexure N, my lord, the memorandum.
You will say that it was not communicated to you. That is why you had approached this court earlier.
Yes,
And
my
there
lord.
was a direction by this court
Yes, my lord.
to consider and pass necessary orders.
Yes, my lord. My lord, as per annexure N, my lord, the similar applications, my lord, have been granted.
Huh? Seeking grant of land.
Yes, my lord.
Grant of land ಕೇಳಿದ್ರೆ ನೀವು ಅದೇ ಪರ್ಟಿಕ್ಯುಲರ್ ಲ್ಯಾಂಡ್ ಕೊಡಬೇಕು ಅಂತ ಹೆಂಗ್ ಕೇಳ್ತೀರಾ?
My lords, in survey number 18, my lords, the availability of land is there, my lord, to the extent of 39 acres.
ಹಂಗಾಗೋದಿಲ್ಲ.
My lords, other persons have been granted land, my lord, that has been placed, my lord, at page number 56, my kindly be seen, my lord, the index of land.
Let us learn it. AGA. ಏನ್ರಿ ಬರೀ ತಹಸೀಲ್ದಾರ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಲ್ರಿ ನೀವು?
My lords, the annexure A was issued by the Tahsildar itself, my lord. Tahsildar has been issued. ಅದೊಂದು ಎಂಡರ್ಸ್ಮೆಂಟ್ ಮಾತ್ರ ನಾನು ಚಾರ್ಜ್ ಮಾಡ್ತೀನಿ. It was issued by the Tahsildar, my lord.
ಅಲ್ಲ, but what were the directions issued earlier?
My lord, the representation was given by the petition.
Direction was issued to whom?
My lord, to the Tahsildar, my lord, page number 61, may kindly be seen.
However, if a direction is issued to respond number 2.
Respond number 2, my lord, in the writ petition.
Tahsildar.
Tahsildar, my lord, page number 58.
Consider the representation. Already, why are you asking for a particular piece of land?
Since, my lord, they were in the possession of the land since some long years, and their applications was rejected, and that was also not.
In that case, it falls under section 94A.
Yes, my lord.
For regularization of unauthorized occupation.
Yes, my lord.
ಇದು ಆ ತರದಲ್ಲ ಇದು.
Yes.
ಏನ್ ಮಾಡ್ತೀರಾ?
ಬೇರೆ ಎಲ್ಲರೂ ಕೊಡ್ಲಿಕ್ಕೆ ಒಂದು ಲಿಬರ್ಟಿ
ಬರ್ಕೊಳ್ಳಿ. ಏನ್ ಹೇಳಿದಮ್ಮ? ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಆಯ್ತಲ್ಲ? Learned AGA takes notice for the respondent Tahsildar. Next para. The petitioner had made an application seeking grant of class 1 category of lands under the provisions of the Karnataka land grant rules. 1962-69. So, when the applications were not considered, the petitioner approached this court in WP number 7707-7711 of 2019, along with the petitioners. 4 ಜನ ಇದಾರಲ್ಲ ಇಲ್ಲಿ. Along with the other applicants. Full stop. This court, by order dated 6/9/2019, second sentence to that. It was noticed by this court that the petitioners claimed to be in occupation of certain lands, and the revenue inspector had prepared a memorandum depicting thereunder the extent of land in occupation of each of the petitioners. So, the Tahsildar had issued a certificate stating that he had no objection for disposal of the land in question. Full stop. However, it was noticed that lands were granted in favor of one Shri H.G. Lakshmish, a retired army soldier, in the same survey number, measuring 4.38 acres under section 71 of the Karnataka Land Revenue Act, 1964, which was also approved by the Deputy Commissioner on 13/7/2018. Full stop. It was noticed that there was a total extent of 61.36 acres in survey number 18, and whereas 39 acres were reserved for class 1 category to which the petitioners belong. Full stop. Noticing all the above aspects, this court directed the respondent Tahsildar to consider the representations dated 4/1/2019 made by the petitioners and to expeditiously dispose of the applications, however, within an outer limit of 8 months from the date of receipt of a certified copy of the order. The respondent Tahsildar has issued the impugned endorsement dated 26/8/2021. So, it is stated in the impugned endorsement that the remaining lands in survey number 18 cannot be allotted to the petitioners, since the MPM andre Mysore paper mills, since trees were grown on the remaining extent of land by Mysore Paper Mills Limited, which requires the trees for the purpose of the industries. Stop. Next paragraph. What is required to be noticed is that these submissions were not made, or these aspects were not brought to the notice of this court while the earlier writ petition was disposed of by this court. We will do one thing. We will not dispose of this matter. Yakandre matte ade tappu madadanga agutte. Please secure instructions.
Yes, sir.
Huh? etc. Therefore, the learned AGA is directed to secure instructions from the respondent Tahsildar as to the extent of land in use and occupation of the Mysore Paper Mills Limited, and whether any other class 1 category of lands are available for grant to the petitioners. Yes. Release this matter on 24th of February.
Petitioner request to have the stay, civil court stay as civil court order, the petitioner has filed to suit for partition. So the other has granted stay order. Petitioner may request to the Tahsildar to enter the stay order in the call number 7 of the artist. Suit properties.
ಏನಂತ stay?
Stay not to alienate the property.
Injunction.
Injunction. But Tahsildar has denied my request by virtue of the order passed with the
Where is the need for entering all this in the revenue record?
Right, this order will put that in.
Sir, there is an order passed by the competent civil court granting an order of temporary injunction against the defendants. The defendants know that they cannot alienate the property. Why it should be entered in the revenue records?
Right, for the purpose of that, to in order to avoid.
Not necessary.
This order.
Not necessary.
Right, this order will put passed the order annexure G page number 34.
Ah.
These similar endorsements were passed by this order will put.
You know?
This type of similar endorsements passed with this order will put. Annexure F page number 34. The last operating question page number 54. Such circular dated 25.
Sir, it's not enough if you just point out to the operative portion. Where was the need for the compulsory noting of this in the RTC? Adan Odi.
Number 11, this is the same request, in page number.
Allare. Anyway, there is an order. You are secured at the hands of the competent civil court. Where is the compulsion that such orders have to be entered in the revenue records?
127 1B, page number 50. Legal provision. Para number 8.
127 1B.
Para number 8 in legal parlance, ordinarily liability means legal responsibility for one's act and omission, or in any other words, means the application to responsible or answerable in law. And when this expression is read in conjunction with a requirement under section 127.
A record of rights shall be prepared in the prescribed manner in respect of every village, and such record shall include the following particulars: BLA, the nature and extent of the respective interest of such persons, and the conditions or liabilities, if any, attached thereto.
Liabilities column, and I seek for entry the stay order in liability column. 11, column number 11 of RTC. RTC is only 11 column is only for liability center column. Itara runagalu. Column number 11. Akkugulu ಮತ್ತೆ ಋಣಗಳು. That column we request for enter this order. And this statute earlier this court was.
ಅಲ್ಲ ಏನಾದ್ರಾಗ್ಲಿ why should the revenue authorities bother about it? ಅಲ್ವಾ? ಸರಿ, ಅದಕ್ಕೇನೆ you will not arrest the defendants as parties here.
Similar endorsement issue with the Tahsildar. Endorsement issue with the Tahsildar.
ಹೌದ್ರಿ, should the other side not have their say?
In this repetition,
Then we can know whether it is that was vacated or not.
No, madam, it was extended.
Sir,
But I will produce the.
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಲ್ಲ, You should have arrayed them as party respondents here.
Sir, in this court, my lord, annexure F, my lord, only the Tahsildar is party. Similarly, the judgment was possible.
For everything you want to point out to another order passed by this court, is it?
I will make parties, my lord.
Ashte, it is as simple as that. At the request of oral request of the learned counsel for petitioner, the contesting defendants,
Depend number one.
huh?
Depend number only the one.
Contesting defendants, that is defendant number 1, invoice number
Voice number 777.
hmm,
7127 for 21.
pending on the file of
File of CH party one. CH party one.
the court elderly.
City civil and session judge.
He is permitted to be arrayed as respondent number 4 to this writ petition. Learned counsel is permitted to carry out the amendment in the cost rate. Full stop. Learned next para. Learned AGA takes notice for response number 1 to 3. Issue emergent notice to the newly implemented respondent number 4. Full stop. The petitioner is also permitted to take out hand summons to the 4th respondent. Release this matter on 24th of February.
Serial number 9, Ganapati Bhatt.
Please, my lord.
Yes.
I appear for the learned advocate for the petitioner, my lord.
Yes.
The challenge is to annexure A, page 24, my lord. Whereby a short order, I pray the honorable court to permit me.
2010.
Please. It's for this reason, my lord. ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 14/8/2007 ಅರ್ಜಿಯನ್ನು ನೀಡಿ ತನಗೆ ಭೂಮಿ
At any rate, interim relief cannot be granted, sir.
Please, my lord.
He will only issue notice.
My lord, please.
He will only issue notice.
Please. One sentence
for response number 1 and 2. Issue emergent notice to response number 3 to 6. Yes.
Please, your lordship may call after. Please. Yes. I may be also permitted to take hand summons, my lords, hand notice on 3 to.
The petitioner is also permitted to take out hand summons to response number 7.
Grateful.
Yes.
Shivkumar.
79 AB na ಯಾವಾಗ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿರೋದು 2018 ಎಲ್ಲಿದೆ ಅದು ನೋಟಿಸ್ ಅನ್ನು ಕಳಿಸಲಾಗಿದೆ. ಈ ವಿಳಾಸದಾರರು ಬಟವಾಡೆ ಪತ್ರದಲ್ಲಿ ನೀಡುವ ವಿಳಾಸದಲ್ಲಿ ಇಲ್ಲವಾದ್ದರಿಂದ ವಾಪಸ್ ಕಚೇರಿಗೆ learned AGA take notice for all the respondents. Same as WP number 24309 of 2021. Yes.
For the petitioner,
Yes.
Lord, the petitioner is cultivating the land. Unauthorized cultivating the land, my lord, from the year 1964, my lord. My lord, the petitioner is unauthorizedly cultivating the land, my lord, in survey number 25. There is 2 acres 20 guntas, my lord, from the year 1973-74, my lord. Lord, in the year 1980, my lord, the Taluk surveyor has prepared the check in respect of the unauthorized cultivation of the land in survey number 25, my lord. Annexure A, my lord, sketch prepared by the Taluk surveyor, my lord. As per the sketch, my lord, my name was mentioned at seal number.
There is no interim prayer.
Please, my lord.
There is no interim prayer. It's only a writ for mandamus.
Yes, my lord. Subsequently,
to consider your application for regularization.
Yes, my lord. They have collected TT, my lord. The TT charges was collected as per the order passed by the third respondent, my lord. Annexure B is the order passed by the Assistant Commissioner, my lord. There it is the Tahsildar to collect the TT charges from the petitioner in respect of the unauthorized occupation of the land. Annexure B, my lordship. Taped copy, my lord, is 24, page number 24, my lord. May I read, my lord? ಅಪೀಲುದಾರರು ತಮ್ಮ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಅರೇಳಿ ಹೋಬಳಿ ಸಾಣೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಬಾಬ್ತು ಸರ್ವೆ ನಂಬರ್ 25ರಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು 1974ನೇ ಸಾಲಿನಿಂದಲೂ ಬಗರುಕುಂ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವುದಾಗಿಯೂ ಬೇಲೂರು ತಹಶೀಲ್ದಾರರು ತಮ್ಮ ನಿಂಬರ ಕ್ರಮಾಂಕ ಸೋಂಟು ದಿನಾಂಕ 6/5/88ರಲ್ಲಿ ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ ಪ್ರದೇಶದಲ್ಲಿ ಅನಧಿಕೃತ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದನ್ನು ಖುಲ್ಲಾ ಮಾಡಬೇಕೆಂದು ತಿಳಿಸುತ್ತಾರೆಂದು ಮತ್ತು ಆಜ್ಞೆಯನ್ನು ಜಾರಿಗೊಳಿಸದಂತೆ ಹಾಗೂ ಈ ಜಮೀನಿಗೆ ಟಿಟಿ ಜುಲ್ಮಾನೆಯನ್ನು ವಿಧಿಸಬೇಕೆಂದು ಮತ್ತು ಜಮೀನು ಮಂಜೂರು ಮಾಡುವುದಕ್ಕೆ ಕೋರಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ತಡೆಯಾಜ್ಞೆ ಕೊಟ್ಟಿದ್ದು ಆನಂತರ ತಹಶೀಲ್ದಾರ್ ಅವರಿಂದ ಖಂಡಿಕೆವಾದ ಉತ್ತರವನ್ನು ಪಡೆಯಲಾಯಿತು. ತಹಶೀಲ್ದಾರರು ದಿನಾಂಕ 21/88ರಂದು ಕಳುಹಿಸಿರುವ ವರದಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 25ರಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ 1 ಎಕರೆಯಲ್ಲಿ ಕಾಫಿ ಗಿಡಗಳನ್ನು ಹಾಕಿರುವುದಾಗಿಯೂ ಮತ್ತು 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಾಗದಲ್ಲಿ ಕುಷ್ಕಿ ಬೆಳೆ ಹಾಕಿರುವುದಾಗಿಯೂ ತಿಳಿಸಿರುತ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 25ರಲ್ಲಿ ಒಟ್ಟು 104.24 ಸರ್ಕಾರಿ ಗೋಮಾಳ ಇರುತ್ತೆ. ಪಾಣಿಯ ನಕಲನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದಾಗೆ 1977-78ರಿಂದ ಚೆನ್ನೇಗೌಡ ಬಿನ್ ಹುಚ್ಚೇಗೌಡ ಎಂಬುವರು 2 ಎಕರೆ 20 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಬಗರುಕುಂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದಾಗಿರುತ್ತೆ. ಅಪೀಲುದಾರರು ಅಲ್ಲದೆ ಇನ್ನೂ ಹಲವಾರು ಜನರು ಈ ಸರ್ವೆ ನಂಬರ್ನ ಜಮೀನುಗಳನ್ನು ಅನಧಿಕೃತ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ದೃಢಪಟ್ಟಿದೆ. ಈ ಮೇಲ್ಕಂಡ ಕಾರಣಗಳಿಂದ ಮತ್ತು ಕಡತಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅಪೀಲುದಾರರ ಮೇಲ್ಮನೆಯನ್ನು ಈ ಕೆಳಗಂಡ ಕಾರಣಗಳಿಂದ ಎತ್ತಿ ಹಿಡಿದಿರುತ್ತೆ. ಪಾಣಿಯಲ್ಲಿ 1977-78ರಿಂದಲೂ ಅಪೀಲುದಾರರು 2 ಎಕರೆ 20 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಬಗರುಕುಂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವುದು ಕೃತವಾಗಿದೆ. ಆದ್ದರಿಂದ ತಹಶೀಲ್ದಾರ್ ಟಿಟಿ ಜುಲ್ಮಾನೆಯನ್ನು ಕಾನೂನು ರೀತ್ಯ ವಿಧಿಸಿ ಅಪೀಲುದಾರರಿಂದ ಮೊಬ್ಬಗಳನ್ನು ವಸೂಲು ಮಾಡಿ ಸರ್ಕಾರಕ್ಕೆ ಜಮಾ ಮಾಡುವುದಕ್ಕೆ ಆದೇಶಿಸಿದೆ. Lord, this is the order, my lord, passed by the Assistant Commissioner in the year 1988. Pursuant to this, my lord, the fourth respondent has issued a notice as per Annexure E imposing TT charges, my lord, penalty charges. And my lord, I have paid the charges, my lord, as per Annexure D, my lord. Between the year 1988 to 93, my lord, I have paid the TT charges to the government. Annexure D, my lord. My lord, after collecting the DD charges, my lord, the Tahsildar, my lord, has issued an endorsement to my application stating that, my lord, you have not filed an application in form number 50, my lord. Annexure, my lord, E, my lord, 47, my lord. Taped copy is at 48. ಉಲ್ಲೇಖದ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಅರೇಳಿ ಹೋಬಳಿ ಸಾಣೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 25ರಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಬಗರುಕುಂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದು ಅದನ್ನು ಸಕ್ರಮಗೊಳಿಸಿ ಕೊಡುವುದಕ್ಕೆ ಕೋರಿರುತ್ತೀರಿ. ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ನಮೂನೆ 50ರ ಅರ್ಜಿಗಳನ್ನು ನೋಂದಾಯಿಸಿಕೊಳ್ಳುವ ವಹಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ನೀವು ಹಿಂದೆ ನಮೂನೆ 50ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ದಾಖಲಾಗಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ಅರ್ಜಿ ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ನಿಮ್ಮ ಅರ್ಜಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ವಿಲೆ ಇಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಯುವುದು. The form number 50, my lord, was inserted only in year 1991, my lord. 91. Lord, I am in the cultivation of the land, my lord, from the year 1973-74.
Sorry, this endorsement was issued to you in the year 1998.
Please, my lord.
What were you doing?
My lord, after that, my lord, I filed appeal before the again, my lord, third respondent, my lord, as per Annexure, my lord, J, my lord. Annexure J, page number 55, my lord. My lord, the endorsement was issued as per Annexure K, my lord, stating that, my lord, this appeal is ವಿಚಾರಣೆಗೆ ಅಂಗೀಕರಿಸಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, ನೀವು filed it in 2019.
ಅಲ್ಲ, not on the ground of delay, my lord. They are not stated any reason for not accepting the appeal for consideration. They have simply issued an endorsement stating that, my lord, ವಿಚಾರಣೆಗೆ ಅಂಗೀಕರಿಸಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Tahsildar, my lord, while submitting the report before the Assistant Commissioner, has specifically stated that, my lord, petitioner is under unauthorized cultivation of the land since from the year 1973-74. and my name was also entered in the RTC, and they have also collected the TT, my lord, TT charges.
ಏನ್ರಿ ವಾಟ್ ಇಸ್ ದಿಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಈ ತರ ಕೊಟ್ರೆ ಏನು ರೀಸನ್ ಇಲ್ಲ, ಸಿಂಗಲ್ ಲೈನ್ ಆರ್ಡರ್. ಅದೇ ಬರ್ಕೊಳ್ಳಿ. Learned AG takes notice for all the respondents. Learned counsel for the petitioner submits that the petitioner is in unauthorized occupation of 2 acres and 20 guntas of land in survey number 25 of Sanenahalli village, Arehalli Hobli, Velur Taluk, Hassan district. Since 1973-74. Full stop. The petitioner had sought for regularization of unauthorized occupation. Full stop. In this regard, the Assistant Commissioner passed an order dated 9/11/1988 in Proceedings number RA 6 of 1988-89, where the Tahsildar is the respondent, directing the Tahsildar to collect TT fine from the petitioner and TT fine, full stop. Accordingly, TT fine was collected from the petitioner, as could be seen from the documents submitted at Annexure D series. Full stop. Prior to that, the Tahsildar had in fact issued a notice dated 16/3/1989 calling upon the petitioner to pay the TT fine, totaling ₹9,190. The said amount has been paid as TT fine, way back in the year 1989. Stop. Thereafter, instead of entering the name of the petitioner in the land revenue records by issuing Sagoli chit, an endorsement dated 24/9/1998 was issued by the respondent Tahsildar, stating that application in form number 50 was not filed by the petitioner and the same is not reflected in the register maintained for receiving the application. Full stop. Therefore, the request of the petitioner for regularizing his unauthorized occupation was rejected. So, aggrieved, the petitioner once again approached the assistant commissioner in proceedings bearing number appeal ಹೊಡೆದ್ಬಿಟ್ಟು ಏನೋ ಬರೆದಿದಾರಲ್ಲ
160 bar
revision number 160
REML
2019-20 invoking section 49 capital A of the Karnataka Land Revenue Act, 1964. The assistant commissioner has issued the impugned endorsement, which is a one-line endorsement stating that it is not possible to consider the revision filed by the petitioner. Stop. Next paragraph. Then a counsel for the petitioner submits that the provisions contained in section 94 capital A for regularization of unauthorized occupation was introduced in the Karnataka Land Revenue Act, in the year 1991. So, by Act number 2 of 1991, with effect from 20th of March 1991. Stop. Learned counsel therefore submits that the respondent Tahsildar could not have issued such an endorsement stating that there was no application in form number 50 filed by the petitioner. Stop. Moreover, the assistant commissioner has simply rejected, simply declined to consider the appeal bar revision filed at the hands of the petitioner. Stop. At any rate, the impugned orders by endorsement cannot be sustained. Full stop. Next para. Consequently, this writ petition stands disposed of, while setting aside the impugned endorsements dated 24/9/1998 issued by the respondent Tahsildar and endorsement dated 29/11/2019 issued by the respondent assistant commissioner at annexure K. Stop. The assistant commissioner is hereby directed to consider the revision bar appeal filed by the petitioner herein, taking into consideration the observations made by this court. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಯಾವ್ದು the grievance of the petitioner is required to be considered in terms of the provisions contained in 1970. ಆಮೇಲೆ ಇಲ್ಲಿ ಈಗ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಏನ್ ಹೇಳಿದ್ವಿ?
Commissioner is hereby directed to consider the revision from public appeal filed by the petitioner hearing, taking into consideration the observation made by the court.
And pass necessary orders for regularization and for issuance of Sagoli chit in favor of the petitioner, as expeditiously as possible, and at any rate within a period of 2 months from the date of receipt of a certified copy of this order.
Appearing for the petitioners, my lord. Milords, we have engaged senior counsel in this matter, milords. He's not in town due to some urgency, milords. Request your lordship to kindly grant 2 weeks time, milords.
Special order. At the request of learned counsel for petitioner, discuss matter after 2 weeks.
Grateful, milords.
Yes.
ಎಲ್ಲಾ ಸುದ್ದಿ ಒಂದು ಮಧ್ಯಾಹ್ನ ಎಲ್ಲ ಸಹ ಒಂದು ಮಧ್ಯಾಹ್ನ was granted 2 acres of land in the year 1984. I will take the page number 47 and just see. Page number 49 you can see. 3rd July 1984. I filed right copy. That's only the one. Page 49 dated 23rd July 1984. But this land was subject matter of the declaration filed by Murugapura regarding excess land. And as well as said, it is being allowed.
Grant of surplus land.
Yes.
Under section 77.
Yes.
Of the Karnataka Land Reforms Act.
Yes.
1961.
Yes. This is the B mechanism. This is order page number 40. This is the order dated 12/11/1981. Passed by the land reform right now. But in this matter, in extent of page number 42.
Who had filed this? Form number 7.
11.
Form number 11.
Yes. Under section 66 law of land reform, declaring his land total excess land. There, Lord, he is required to give all, including the land sold by him during the relevant time. Here, Lord, the Murugappa has suppressed one item of land about 10 acres. If that is included, now Lord, this land will still more be surrendered to the government. Out of that land, Lord, he was granted 2 acres of land. And it's the 42 page 42. But I would fix the line. Sadari 97.29 ಗುಂಟೆಗಿಂತ ಹೆಚ್ಚಾಗಿರುವ 244 ಸರ್ವೆ ನಂಬರ್
ಪೂರ್ತಿ ಓದಿ ಆದೇಶ ಪೂರ್ತಿ ಓದಿ.
1ನೇ ಅರ್ಜಿದಾರ ಮುರುಗೇಗೌಡ ಹೊಂದಿರುವ ಎಲ್ಲಾ ಭೂಮಿಯನ್ನು ಪರಿಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಇನಾಮ್ ರದ್ದತಿಯಾಗಿ ಕಾಯ್ದೆ 1955 ಕಾಲಂ 4 ಪ್ರಕಾರ ಅರ್ಜಿದಾರರ ಮುರುಗೇಗೌಡನನ್ನು ಗೇಣಿದಾರರನ್ನು ಪರಿಗಣಿಸಿ ಮಿಲಿಕಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಅರ್ಜಿದಾರರಿಗೆ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಒಮ್ಮತದಿಂದ ಕಾಯ ಮಾಡಿದೆ. ಉಳಿದ ಸರ್ವೆ ನಂಬರ್ 241 8 ಎಕರೆ 30 ಗುಂಟೆ 236 4 ಎಕರೆ 11 ಗುಂಟೆ ಒಟ್ಟು 13 ಎಕರೆ 1 ಗುಂಟೆ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ 16ರಲ್ಲಿ ಕಲಂ 63 ಪ್ರಕಾರ ಅರ್ಜಿದಾರರನ್ನ ಸ್ವಂತ ಎಂದು ಹೇಳಿ ವರ್ಗದ 42.1 ಗುಂಟೆ ಇದ್ದು ಅದರಲ್ಲಿ 3 ಎಕರೆ 15 ಗುಂಟೆ ಕ್ರಯವಾಗಿದ್ದು 5 ಎಕರೆ 37 ಗುಂಟೆ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಕಲಂ 48 ಕ್ಯಾಪಿಟಲ್ ಎ ಪ್ರಕಾರ ಗೇಣಿದಾರರಿಗೆ ಉಳಿದ 97 ಎಕರೆ 7 ಗುಂಟೆ ಜಮೀನು ಗಂಟೆಗೆ ಮಾತ್ರ ತರಲಾಗಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಕ್ಯಾಂಡಿ ಸದರಿ 97 29 ಗುಂಟೆಗಿಂತ ಹೆಚ್ಚಾಗಿರುವ
97 ಎಕರೆ 97 ಎಕರೆ
ಕರೆಕ್ಟ್ 97 ಎಕರೆ 29 ಗುಂಟೆಗಿಂತ ಹೆಚ್ಚಾಗಿರುವ 241 ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿನ 8 ಎಕರೆ 30 ಗುಂಟೆ ಸರ್ವೆ ನಂಬರ್ 236 4 ಎಕರೆ ದಿಸ್ ಇಸ್ 236 4 ಎಕರೆ 10 ಗುಂಟೆ ಕಲಂ 66 ಪ್ರಕಾರ ಸರ್ಕಾರಕ್ಕೆ ಬರಬೇಕಾಗಿರುವುದರಿಂದ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ಕಾಯ ಮಾಡಲು ರಹವಿರುವುದಿಲ್ಲ. ಇದಲ್ಲದೆ 24/71 ನಂತರ ಕ್ರಯ ಮಾಡಿರುವ 1 ಎಕರೆ 15 ಗುಂಟೆ ಸೇರಿ ಒಟ್ಟು 14 ಗುಂಟೆ ಈ ವರ್ಗದ ಜಮೀನು ಭೂಸುಧಾರಣಾ ಕಾಯ್ದೆ ಕಲಂ 66 ಪ್ರಕಾರ ಕಲಂ 63ರ ಮಿತಿಗಿಂತ ಹೆಚ್ಚಾಗಿದ್ದು ಬಿಯಾಂಡ್ ಚಿಲಿ ಸರ್ಕಾರಕ್ಕೆ ಪಡೆದಿದ್ದಾಗಿ ಘೋಷಿಸಿದೆ. ದಿಸ್ ಇಸ್ ನಾಟ್ 236 ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ 4 ಎಕರೆ 11 ಗುಂಟೆಯಲ್ಲಿ ನಮಗೆ ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. This was allotted to me in the year 1984. This whole thereafter this order was taken in petition to the Congress. And this order
was forfeited to the government.
Yes.
From out of that land,
Yes.
2 acres were granted to you.
No, this order was taken in the petition. And that order was set aside and man has been remanded. That I will take result page number 56 annexure D. Petitioner staff, the eldest staff, the original owner, Mugge Goda. Page 56 annexure D. Alama, Nagar Goda, there are original there are some kindly seen. The respondent number 9, Badya Naika. Number 9. This order has been set aside and man has been remitted.
Yes.
Kindly. Page number 60. In view of this, the impure order set aside and the matter is remitted to the tribunal for fixing the correct ceiling limit after taking into account submissions made to the parties. The tribunal is directed to give notice to all the respondents who were served and remind expert before this court. Then kindly the fresh order has been passed. No, not kindly. I will take page number 66. After this remand, this order dated 21 March 2018, page 66. ಒಟ್ಟು ಜುಮ್ಲಾ 113.32 ಎಕರೆ ಈ ಜಮೀನಿನಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ 108 ಎಕರೆ ಬರುತ್ತದೆ. ಈ ಹಿಂದೆ ಮಾಡಿದ ಆದೇಶದಲ್ಲಿ ಬಿಳಿಕಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 241ರಲ್ಲಿ 7 ಎಕರೆ 21 ಗುಂಟೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 236ರಲ್ಲಿ 4 ಎಕರೆ 7 ಗುಂಟೆ ಜಮೀನನ್ನು ಹೆಚ್ಚುವರಿ ಎಂದು ಪರಿಗಣಿಸುವ ರದ್ದುಪಡಿಸಿ ಅರ್ಜಿದಾರರಿಗೆ ಈ ಹಿಂದೆ ದಿನಾಂಕ 12/11/2023 ಹೋಗು 13 ತಾರೀಕಿಗೆ ಕೊಟ್ಟ ಜಮೀನನ್ನು ಹೊರತುಪಡಿಸಿ 5 ಎಕರೆ 32 ಗುಂಟೆ ಜಮೀನು ಕಲಂ 63 ಪ್ರಕಾರ ಹೆಚ್ಚುವರಿ ಎಂದು ಘೋಷಿಸಿ ಮತ್ತು ಅರ್ಜಿದಾರರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 246ರಲ್ಲಿ 5 ಎಕರೆ 36 ಗುಂಟೆ ಎಕರೆ ಜಮೀನಿಗೆ ಅಧಿಕೃತ ಆದೇಶಿಸಿದೆ. ಉಳಿದ 5 ಎಕರೆ 37 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 241ರಲ್ಲಿ 1 ಎಕರೆ 25 ಗುಂಟೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 236ರಲ್ಲಿ 2 ಎಕರೆ 4 ಗುಂಟೆ. Now they reduced it. So consequently, not my extent to grant earlier was reduced. No, not kindly see the procedure for filing Form 11. Kindly see Form 11. I have produced not a page number 90. And that's for the original form. Annexure A. See the form not kindly see. This I will take 11 portion. Page number 28. The second form number. 1973ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ನರ್ಸಾಪುರದ ಮಲ್ಲಪ್ಪ ಬಿನ್ ಒಳಿಯಪ್ಪನಿಗೆ ಮಾರಾಟ ಮಾಡಿದೆ. This has not given the area extent. He has suppressed. This he has to include while arriving not for the total extent. The second also ನರ್ಸಾಪುರದ ವಾಸಿ ಮಲ್ಲಪ್ಪನಿಗೆ 73ರಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದೆ. This is kind. I will read the extent land the thousand of law. I quoted.
Right. All right. Then AGA takes notice for response number 1 and 2. Issue emergent notice to response number 3 to 20. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures from the learned AGE. Next para. Learned counsel for the petitioner submits that in terms of the earlier order passed by the land tribunal on an application made in form number 11 at the hands of Sri Murugyappa Gowda, since dead and now represented by response number 3 to 11, a declaration was made by the land tribunal in its order dated 12/11/1983.
81. Answer B.
Answer B for Bangalore. 12/11/1983 ಅಂತ ಇದೆ ಅಲ್ಲಿ.
81.
ಪೇಜ್ ನಂಬರ್ 42 ಬನ್ನಿ.
42 81.
ಕೆಳಗಡೆ ಅಧ್ಯಕ್ಷರು
ಸೈನ್ ಮಾಡಿದ್ದು ಮೇಲ್ಗಡೆ ಹಂಗೆ ಬಂದಿದ್ದಾರೆ. 81 ಅಂತ ಬಂದಿದ್ದಾರೆ.
ಇದು ಟೈಪ್ ಕಾಪಿನ ಇದು? ಇಲ್ಲ, ಇದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
ಟಾಪ್ ಅಲ್ಲಿ 81 ತೋರಿಸಿದ್ದಾರೆ.
ಹಾ,
ಈಗ ಆರ್ಡರ್ ಸೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 83 ತೋರಿಸ್ತಾರೆ.
ಆಯ್ತು. 12/11/1981 ಏನ್ ಹೇಳ್ದೆ?
A declaration was made by the land tribunal in its order dated
that Sri Murugappa Gowda was not entitled to hold. ಯಾವ್ದದು? ಸರ್ವೆ ನಂಬರ್
236 4 acre 11 ಗುಂಟ.
4 acre 11 guntas in survey number 236 of
Bilki village.
Bilki village, and the same was forfeited to the government along with the certain other lands. Full stop. However, the subject matter of this litigation is confined to the said extent of 4 acres 11 guntas in survey number 236. Full stop. Next para. After the order was passed by the land tribunal declaring the excess land, the Shri Badiya Nayak, husband of the first petitioner and father of the other petitioners, was granted 2 acres of land.
2 acre 5 guntas.
2 acre 5 guntas of land in survey number 236 of Bilki village. Full stop. However, the order dated 12/11/1981 was challenged by Murugappa Gowda before this court in WP number. The legal representatives of Murugappa Gowda was challenged before this court in WP number 15469 of 1993. Full stop. This court, by order dated 2/11/2000, set aside the order of the tribunal and remanded the matter back to the tribunal for refixing the correct ceiling limits after taking into consideration the submissions made by the parties. Full stop. Consequently, the impugned order dated 21/3/2018 was passed by the land tribunal, holding that in survey number 236 the Dibada Murugappa Gowda was not entitled to hold 2 acres and 4 guntas. Stop.
Number 236.
Huh?
Number 236.
236 bantu. This order affects the rights of the petitioners, since 2 acres have already been granted to the petitioners. 2 acres 5 guntas in survey number 236, consequent to the earlier order passed by the land tribunal. Moreover, learned counsel for the petitioner points out from form number 11 filed at the hands of Murugappa Gowda, at annexure A, that Sri Murugappa Gowda had in fact declared in the application that in the year 1973 he had sold
Lands itself very low. Suppress money.
he had sold lands.
Narsapura village. Narsapura village to Mallappa
at Narsapura village in favor of Mallappa, son of Oliyappa. And this has not been noticed by the land tribunal. Full stop. Next para. There shall be an ad interim order of stay of the impugned order dated 21/3/2018, comma, insofar as survey number 236 of Bilki village is concerned, comma, till the next date of hearing.
Notice for timing to respond 12 to 20 will be dispensed with the thing, not be. They are also granted earlier.
Ali starting ali notice to
12 to 20.
ali issue emergent notice to response number 3 to 11. Notice to response number 12 to 20 is dispensed with, comma, at the request of the learned counsel for petitioner, since these respondents are also the beneficiaries of the earlier order passed by the land tribunal, and they are not, their rights are not affected.
It will be affected once this order goes in, the mat has to go back. That's why at present not there.
ಆಯ್ತು ಅಷ್ಟ ಆಗ್ತದೆ ಸಾಕು.
Yes. In this case, the petitioner father purchased the immovable property bearing survey number 16 measuring 1 acre 12 guntas in Gattalli village, Sarjapur Hubli, Anekal Taluk, under registered sale deed dated 9/9/1970. Annexed page 15. So, during the lifetime of his father has given the representation, the respondent cannot consider. After that, these petitioners have given also representation.
Yeah.
So the representation to change the revenue record, seeking for mandamus in this case.
Who purchased the property?
My father, no. And the registered sale deed dated 9/9/1971.
1971.
Yes.
Why is it that your father did not?
My father, he was not keeping well. And also in the year 1997, he died. Thereafter, his wife was pursued. She also expired. And now these petitioners are pursuing this matter. And also, pursuant to the representation given by this petitioner, the concerned authority has given directed annexure H and J. Actually, there is a Sukwaranta Kamatavali on page 46 and 47. Annexure H and J. Pursuant to the representation given by this petitioner and earlier his mother, the respondent, that the special deputy commissioner, and also this page 46 annexure H. 47.
ಏನ್ರಿ ಇದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ರೈಟ್ಸ್ ಟು ದ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ at annexure H, page number 45.
Special deputy commissioner.
Alala, I want to understand what this is.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. annexure J ನಲ್ಲಿ ಸ್ಪೆಷಲ್ ಡಿಸಿ ಹ್ಯಾಸ್ ಫಾರ್ವರ್ಡೆಡ್ ಟು ದ ತಹಸೀಲ್ದಾರ್.
Who is the authority to consider the application for goods?
Annexure J is annexure J, page 47.
You deputy commissioner in turn sent it to the
ತಹಸೀಲ್ದಾರ್.
ಎಲ್ಲಿದೆ?
ಇದು annexure J, page 47.
ಅಪರ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು.
ಹೌದು, ಸ್ಪೆಷಲ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಟು ದ ತಹಸೀಲ್ದಾರ್. ಅವರು ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. So far they have not considered change revenue records in the name of this petitioner.
Alala, whatever it is,
under one section,
if he finds that there is a entry of some other person's name, notice will have to be issued. ಮಾಡದ ಪ್ರಾಬ್ಲಮ್ ಏನು ಅಂತ ನನಗೆ ಅರ್ಥ ಆಗಲ್ಲ. ಹಿಂದೆ ಇದ್ರೆ ದೇ ವಿಲ್ ಡೂ ಎನಿಥಿಂಗ್. ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಯಾರ್ದು ಹೆಸರಿದ್ರು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಲ್ಲ. they'll straight away pass orders mutating the name. Otherwise, they don't even want to issue notice and consider the application pass orders. Huh? ಅದೇ
128 ಅಲ್ಲಿ J form is that is the duty of the
J form ಎಲ್ರಿ ಏನ್ರಿ J form ಗೆ ಸ್ವಲ್ಪ ಲಿಮಿಟೇಷನ್ ಇದೆ. You can't sit tight in your house and say J form ಹೋಗಿದೆ ಅಲ್ಪಾರ್ಗ ಅದ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿವರೆಗೂ ನಾನೇನು ಅವ್ರ ಮೂವ್ ಮಾಡಲ್ಲ ಅಂತ.
ಅವತ್ತು ನಾನು ಪರ್ಸು ಮಾಡ್ತಾ ಇದ್ದೆ.
ಯಾವಾಗಿಂದ 1971 ಇಂದನಾ? ನಿಮ್ ಯಜಮಾನ್ರು ಬದುಕಿದಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಎಲ್ಲ ಟೈಮ್ ಕರೆಕ್ಟ್ ಆಗಿ ಇಫ್ ಯು ಟೇಕ್ ಇನಿಷಿಯೇಟಿವ್ all these problems will not arise, sir. Learned AGA takes notice for all the respondents. Next para. The grievance of the petitioners is that although their father, late Sri M. Jairam, purchased 1 acre, 1 acre and 12 guntas in survey number 60 of Gattahalli village, Sarjapur Hobli, Anekal Taluk, under a registered sale deed dated
9/9/1971.
9/9/1971, comma, his name was not entered in the revenue records. Full stop. In the meanwhile, Sri M. Jairam passed away on
1997. I have produced the death certificate also.
8/8/1997, leaving behind his wife Srimati Saraswati and 2 sons, comma, who are the petitioners here. What's up? Amele
Thereafter in the
Saraswati
2021, that also I produced. 2021 ನಲ್ಲಿ Saraswati expire ಆಗಿದೆ. That is annexure.
Thereafter, Srimati Saraswati also passed away on
9/9/2021.
9/9/2021. Full stop. Twenty-eight. ಏನದು? ಆಯ್ತು. ಏನ್ರಿ ಇದು? ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್?
This is the what happened, Lord. This is not pertaining to this property. ಈ ಪ್ರಾಪರ್ಟಿ ನಲ್ಲಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ನಂಬರ್ ಅದನ್ನ ಬೇರೆ ಮಾಡ್ಕೊಂಡು ಅದು ಸಂಬಂಧಪಟ್ಟ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ, ನಾಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ. ಸೊ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ರಾಂಗ್ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರು ಇದು ಮಾಡ್ಕೊಂಡು ದಟ್ ಮೈ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ನಾಟ್ ಕನ್ಸರ್ನ್ ಟು ದಟ್. ಸೊ ದಟ್ ಇಸ್ ನಾಟ್ ಮೈ ಕನ್ಸರ್ನ್. ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಮ್ಯಾಂಡಮಸ್. ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ನಲ್ಲಿ ಏನಿದೆ ಈ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅವರು ಹೇಳ್ತಾರೆ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇರೆ ಇದೆ, ಅದು ಬೇರೆ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟ, ನನ್ನ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಲ್ಲ, ಅದನ್ನೇ ಇಲ್ಲಿ ರಾಂಗ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳೋದು. ದಿಸ್ ಇಸ್ ನಾಟ್ ಪರ್ಟೈನಿಂಗ್ ಟು ಮೈ ಪ್ರಾಪರ್ಟಿ. ಸೊ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಡೈರೆಕ್ಷನ್. That is not pertaining to this property because property document number is pertaining to some other property. That case is altogether different. This property I produced the sale deed copy. This sale deed registered number is altogether different. This property is not the subject matter in anything. That's why I am thinking of mandamus.
But you should have submitted that earlier also proceedings were initiated. Not that no proceedings were initiated. Proceedings were actually initiated.
Initiated not in respect of this property. That's my submission. Even representation document number registered is allowed. Someone put is better property, not for this property. I produce the sale deed. So our property is someone mandamus. This is altogether different.
Then why have you produced all these copies?
Well, representation or clarification Leonard Fund is reading that. This representation of mother a clarification my Leonard Fund is reading that. My mother has given clarifying that property is different, so this property is different. He is seeking for change the revenue records in my name and representation you
Thereafter, Srimati Saraswati also passed away on 9/9/20.
So, thereafter, representations are made by the petitioners to the concerned authorities seeking to enter their names in the revenue records. Full stop. In this regard, learned counsel for the petitioner has drawn the attention of this court to a communication dated 18/1/2021 at Annexure H made by the
the special deputy commissioner forward to Proceedings 47.
Assistant Commissioner. Sahayaka Ayuktaru andre Assistant Commissioner, ಭೂಮಿ ಉಸ್ತುವಾರಿ ಕೋಶ ಅಂದ್ರೆ
ಲ್ಯಾಂಡ್ ಸೂಪರ್ವೈಸಿಂಗ್ ಸೆಲ್ ಅಂತ ಏನು ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸ್ ಅನ್ನೋದು ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ ಸೂಪರ್ವಿಷನ್ ಸೆಲ್ ಕೋಶ ಅಂತ
land records supervision cell, Bangalore, to the deputy commissioner, Bangalore urban district, bringing to his notice the application made by Srimati Saraswati seeking mutation of her name in the revenue records. The deputy commissioner thereafter directed the special Tahsildar, Anekal Taluk, in his communication dated 5/5/2021 at Annexure J, to take action on the representations given by the petitioners and report the same to the deputy commissioner. Stop. Nevertheless, no action is taken by the deputy concerned Tahsildar. Full stop. Next para. Learned AGA draws the attention of this court to a communication dated 29/12/2020 made by Srimati Saraswati, the mother of the petitioners herein, to the Chief Secretary, Government of Karnataka. Stop. Learned AGA submits that there is reference to earlier proceedings before the revenue authorities and a repetition in WP number 10240 of 2007. Stop. Learned counsel for the petitioner submits that these proceedings do not pertain to the subject matter of this litigation. Full stop. Next para. The grievance of the petitioners is therefore that no action is taken by the revenue authorities on the representations given by the petitioner for entering their name in the revenue records consequent to a registered document. Full stop. Next para. In the light of the above, this writ petition stands disposed of with a specific direction to the fourth respondent, Tasildar, Anekal Taluk, to consider the representations given by the petitioner, issue notice to the person if named in the revenue records, be it the previous owner from whom late Sri M. Jairam purchased the land in question, or any other person whose name stands in the revenue records, grant opportunity of hearing to the parties, and thereafter proceed to pass orders for entering the name of the person who is entitled in accordance with law, as expeditiously as possible, and at any rate within a period of 3 months from the date of receipt of a certified copy of this order. The Tasildar is also entitled to pass necessary orders directing the parties to get a declaration at the hands of a competent civil court, if there is any dispute found on the title of the property. I'll take a short break. I'll come back in 5 minutes.
Court officer. Court of ಇದು ಮ್ಯಾಟರ್ಸ್ ಏನಾಯ್ತು? ಇದು ಆರ್ಡರ್ಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಇತ್ತು.
ರೀಚ್ ಆಗತ್ತೆ ಮೇಡಮ್, ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ.
ಓಕೆ ಸರಿ.
ಬ್ರೇಕ್.
ಓಕೆ 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 ಓಕೆ.
Petition. Petition has some randomized. The Next, here, my last procedure, page number 11. Response number 4. Hearing has obtained the conversion order from the hands of the response number 2, Deputy Commissioner, by suppressing the false, by publishing false information. Answer he has made representation. In turn, the response number 2 has sent a letter to the Tahsildar, response number 3, in page number 32, submit the report. You and treatment, there is no report has been submitted by Tahsildar.
No. See, if a person is aggrieved by an order passed by the Deputy Commissioner under Section 95, what is the course open?
Response number 4 has obtained the conversion order.
Howdo. If someone is aggrieved,
So the order stipulates, my lord,
adena.
Violation is the manner they will take action under Section 96 of the Karnataka Land Revenue Act. That is the condition imposed by conversion of the order.
Huh?
There is a condition violation or furnishing of the false information in terms of the conditions imposed by the Deputy Commissioner while.
How are you concerned with this?
Yes, madam.
How are you concerned with this?
Madam, I am the where my land is towards the southern side. There is no road towards the southern side. Despite my conversion of the order by publishing that there is a road on the southern side, they have obtained the conversion order. In fact, his own sale deed says that there is no road. I have produced page number 27 my academy. Page number 27 the sale deed schedule. For the southern, ದಕ್ಷಿಣಕ್ಕೆ ಇದೇ ನಂಬರ್ ಪೈಕಿ ಬೇರೆ ಯಾವ ಜಮೀನು ಅಂತ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 27 ಶೇಡ್. ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ಲಿ ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ ಮತ್ತು ಇದೇ ನಂಬರ್ ಪೈಕಿ ಸರ್ವೆ ನಂಬರ್ 30 ಬಿಡಿ ಜಮೀನು. ಸರ್ವೆ ನಂಬರ್ 30 belongs to this petitioner.
ಆಯ್ತು.
My land has been shown as the road and has obtained conversion. Therefore,
so what?
Please, madam.
How are you aggrieved?
When he has furnished income
how are you aggrieved by that?
Because my land is towards the southern side is my land.
Aito. Is there any encroachment or has he kept any gate and passing through your property?
Now,
what exactly is your grievance, sir?
My grievance is that when he has taken conversion of the order, he has to give proper information to the Deputy Commissioner. Whereas in contradiction to his own sent document, he has published the correct information and conversion order. The work of that he is showing my land as a road. Therefore, I submitted to the representation of the Deputy Commissioner that we are converting the order. They have not verified properly and they have not issued notice to the neighbors. And conversion has been made out based on the false information. Based on my representation, Deputy Commissioner sent a letter to the Tahsildar to conduct inspection and submit the report.
So, ನೀವು Deputy Commissioner ಇಂದ ಏನ್ ಕೆಲಸ ಮಾಡಿಸಬೇಕು ಅದನ್ನ you are coming and asking the High Court to do that.
My representation still not been considered. Still, my representation.
That is why I asked you, how can you go back before the Deputy Commissioner himself? Under what provision?
The conversion order condition important.
Correct. ತಪ್ಪು ಏನೋ ಮಾಡಿದೆ, ಏನೋ ತಪ್ಪಾಗಿದೆ. What has the Deputy Commissioner, what power has the Deputy Commissioner to reconsider his own order?
Section 96.
96.
Yes.
96 is what? Penalty for using agricultural land for other purpose without permission. Sir, you will have to prefer an appeal under section 49. If there is an order passed by the Deputy Commissioner, then you will have to go before the Karnataka Appellate Tribunal. Learned AGA takes notice for response number 1 to 3. Notice to respond number 4 is dispensed with. The grievance of the petitioner is regarding where is that official memorandum?
Page number 20.
Official memorandum dated 15/11/2014, passed by the second respondent deputy commissioner, Bangalore Urban District, permitting conversion of 3 acres and 24 guntas of land in survey number 30 of Manganahalli village, Yashwantpura Hobli, Bangalore North Taluk, in favor of the fourth respondent herein. Stop. It is not disputed that the said land belongs to the fourth respondent. Stop. However, it is alleged that a wrong boundary is given by the fourth respondent, and he has obtained an order of conversion. Stop. The petitioner has therefore approached the second respondent deputy commissioner, bringing to his notice the discrepancy in the information provided by the fourth respondent while getting the lands converted from agricultural to non-agricultural purposes. Full stop. Then the council submits that the deputy commissioner had in fact called upon the third respondent, Tahsildar, to furnish certain information, with a communication dated 21/12/2020, and till date, no information is made available by the Tahsildar. Full stop. The prayer in this petition is to direct the second respondent deputy commissioner to consider the representation dated 3/11/2020 and for cancellation of the order of conversion passed in favor of the fourth respondent. Full stop. Next para. Learned ATA has raised a preliminary objection that the petitioner could not have approached the deputy commissioner, if he was aggrieved by the order passed by the deputy commissioner. Stop. At best, it is submitted that the petitioner should have filed an appeal under section 49 of the Karnataka Land Revenue Act, 1964, before the Karnataka Appellate Tribunal. Next para. Then a counsel for the petitioner accepts the submission made by the learned AGA and prays that the writ petition may be dismissed as withdrawn, while permitting the petitioner to approach the competent authority by filing an appeal under section 49 of the Act. Full stop. Next para. Consequently, this writ petition stands dismissed as withdrawn with liberty as prayed for. Full stop. Ordered accordingly.
The KVTR respondent number 5.
Serial number 16.
There are 5 matter. Sorry, my lord, one submission, my lord. So, serial number 16 to 20, common order has been challenged. So, in the first petitioner, the notice has not been served to me. Number 1. Number 2, there are second round of litigations, and there are suits also pending. 2 weeks time may be granted, detailed objections will file.
May I argue, Lord? I am appearing for the petitioner.
Yes.
First
So
argument.
in this matter, I have not received the copies.
Kindly see, my lord.
First matter.
No, may
Venkat Reddy avare. Please wait. Please wait. Yes.
16, 17, 19 and 20 arise out of the same order. Now, your lordship may kindly take 20, my lord, where all petitions are filed. All the entire papers have been filed in serial number 20.
Serial number 20.
ಅದರಲ್ಲಿ ಕಾಪಿನೂ ಸರ್ವ್ ಮಾಡಿದ್ದೇವೆ.
418.
Now, in this 20, my lord, we are questioning the order passed by the Assistant Commissioner setting aside mutation entries made about 50 years ago. Kindly see, my lord, at page 69, the first, just take your lordship to some of the relevant documents. Page 69. Is the revenue RTC entry in relation to the survey number 41 of Hirananahalli, Bidaralli Hobli. ಇದು 68-69 ಕೆಂಪಯ್ಯ ಅಂತ ಹೆಸರು ಬಂದಿದೆ. ಕಬ್ಜೆ 10ನೇ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ನಲ್ಲಿ ಕ್ರಯದ ಮೂಲಕ. This is the entry made. Now kindly go to page 91. This Kempaya executes a will. Page 91.
91 RTC.
The RTC na ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Page 91 ನಲ್ಲಿ this serial number 10 column 10 MR will prakara this Kempaya executes the will and it is transferred in the name of Nanjappa, his grandson. Now after this, beloved, there is a partition in the family at page 95. The Nanjappa's family, by a registered partition deed, their names have been entered. This is the petitioner. Page 95. Now, the respondent herein gives a representation to the Tahsildar in the year 2013, and the Tahsildar passes an order at page 229. At page 234. Operative portion. He says, I don't have powers. If you have any problem, at page 234. He says, I don't have any problem. If you have anything, you can either file an appeal or go before the civil court. Now, against this endorsement, they filed the appeal at page 235, the appeal memorandum. This is an appeal filed against this endorsement at page 246. At page 249 ali, when the matter comes up for hearing, they file an application or amendment to challenge several MR entries. The handwriting ali page 249 ali. Adralli sumar entries in this amendment application was filed. And this amendment was allowed on 21/2/2017. Bottom alli or sign madidare. Now, when the matter comes up before Assistant Commissioner, kindly see page 322 is the order sheet in the second volume. Page 322.
ಅಲ್ಲ ನೀವು ಅರ್ಲಿಯರ್ ತೋರ್ಸಿದ್ದು
ಅದು ನಮ್ಮ ಹೆಸರಿಗೆ ಎಂಟ್ರಿ.
ತಹಸೀಲ್ದಾರ್ ಅದ
ತಹಸೀಲ್ದಾರ್ ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದ್ರು. ಅಪೀಲ್ ಹಾಕಿ when the matter comes up for hearing, they file an application for amendment to challenge the MR entries.
ಆಯ್ತು.
ಅದು at page 329 below is the order sheet.
329.
ಅದು ಸೆಕೆಂಡ್ ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ 329. Order sheet ಅಲ್ಲಿ 21/9/2017 case called R68 council present, R4 and R4 council present. A council states for amending, council state or amending the petition under order 10 rule 6 to R45 council present state that several sale dates have been made and subsequent mutation had happened. So many MRs had been done, hence case to be decided on merits. as are the LR3 and not sold any product, so and so. Council pressed to dismiss the case. So case to be decided on merits. Amendment petition allowed. Final order to be produced later considering the amendment. Now he posted passes an order on 3/11/2000, allows the application for amendment. When priorly that challenge to MR itself was not there. Now he sets aside the impugned order is at page 330. Relevant page at page 350. He sets aside entries made in respect of different properties. At page 350, I have carefully examined the contents of the appeal and documents produced by the appellant. I have carefully verified the specific objection filed by respondent number 61, 62, 69, 73. Whereas the contention of other respondent as stated in their objection to amendment application filed by appellant under Order 6, Rule 17 of CPC taken as objections to this appeal. Our objection to amendment application is taken as objection to this appeal. Documents filed by respondents perused in detail. Parties who were present in the open court were also heard in person. Their brief submission also recorded in the order sheet. In view of contesting the appeal by the respondent without objection for delay in filing the appeal, this authority feels that the delay, if any, in filing this appeal under Section 5 was already condoned and necessary amendments to the appeal also carried out. Similarly, application filed by appellants during pendency of this appeal under Order 6, Rule 17 CPC also allowed after hearing parties, as this authority found that the presence of proposed respondent is very much necessary for disposal of this appeal. Said parties, his proposed respondents were brought on record by amending the appeal memorandum. On the very same day, he allows the application and he says condonation, it is deemed to be condoned. Then kindly go to the operative portion, my lord. He says, he sets aside at page 355, MR entries made in 1975, 2003 pertain to different lands at page 355 only, operative portion only. He says notice is not issued to them while making entry somewhere in 69. At 355 top alle. Kindly see at 355 top page only, the possession and entry in their names has become illegal in legal terms. Their possession and entry has become illegal. Their possession has to be treated as non-est. If they are agreed, they may approach civil court or any other forum as may be advised by the legal expert. However, entries under various mutation are to set aside, since without notice of appellant, the said entries were made. To support these contentions, some of the respondents in their objections submitted that during relevant time, there was no procedure of issuing individual notice to affected parties.
That's all right. All right. Yes, Mr. Venkat Reddy.
The first point is the one
anyway this ಇದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
ಇದಾದ್ಮೇಲೆ DC mechanically confirms that order. No reasoning.
All right. You are asking for stay of this
yes,
order.
Lord. Yes.
One
Mr. Venkat Reddy.
One submission. Kindly take out 2394 serial number 2394 17 may kindly see.
ಏನ್ ಹೇಳಿ?
ಅದರಲ್ಲಿ annexure N page 178. See, the point is like this one. On 10/10/2020 and 5/1/2024 and various other dates, the grandfather of this respondent has purchased the entire lands. So he has not sold any person till today. That was examined by the Tahsildar as well as the SC, and also this court also was examined at annexure N. May kindly see, my lord. This court has given police protection also, my lord. Kindly see the annexure N in page 179 in serial number 17, my lord. Serial number 17.
At page 224 is the writ petition direction he is referring to. It is only direction to consider.
No.
Page 224.
So 178, my lord. So then, my lord, kindly
paragraph number really.
Para 4 in the.
Para 4. Really.
Para 6 in the
Para 6.
Para 6. In the present case, the names of some third parties is said to have been entered instead of the names of the petitioners or their father or grandfather in the revenue records. It is said to be illegal on the part of the respondent authorities in making entries in the name of the third parties without taking note of the registered document and the encumbrance certificate, which is said to be standing in the names of family members of the petitioner, that is parent and the grandparent. Thus, according to the learned counsel for the petitioner, on coming to know about the clandestine act of the revenue authorities in making entries in the name of third parties in the revenue record, the petitioners are before this court questioning the same. Section 128, 129 of the Act casts on obligation of revenue authorities and registering authorities before making any entries in the name of some third parties to hold a detailed inquiry when it is the specific contention of the petition that they have not been issued any notice and they have not been heard in the matter before making entries in the names of third parties. Then the act of the revenue entities is illegal. It is for the respondent authorities to make necessary entries in respect of the properties for which the petitioners are said to be the owners and claim to be in possession and enjoyment of the same. If the third person claims to be in possession of the properties clandestinely, contrary to the position of the petitioner, their position be treated as non-honest. Their continuation, if any, after the property was alienated in favor of the grandfather of the petitioner, at the most would be a licenses, except that they have no other right to hold the properties based on some illegal revenue entries. In view of the above, the respondent authorities are directed to consider the representation of the petitioners to make necessary changes in the revenue records for entering their names instead of the names of some third persons. After holding an inquiry under Section 129 Act, if there is any threat to the petitioner's properties, the petitioners can very well seek police protection, and the police shall extend protection to protect the interest of the petitioner's properties. It is for the petitioner to approach the revenue authorities regarding change of entries and seek for the police assistance. Thereafter, so after this, my lord, kindly, so the Tahsildar has made clearly stated. So in the first petition itself, in the 20 first petition, second petition, 16 ನಲ್ಲಿ 2432 ನಲ್ಲಿ.
All right. We will hear you. For the time being, we'll stay the impute order.
No, my lord, sir. I will file any date may be given, madam. I will file.
No, sir.
Because I am a bona fide purchaser. I am in
Yes.
right from 1920.
Their names have also been entered to registered instruments.
Yes, no, they are created all the illegal activities which are.
ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. There is something called a limitation. Even if there is no limitation prescribed, you are required to take action within reasonable time.
No, my lord, I am in position. So thereafter they have filed.
So therefore, if your possession is threatened, go before the civil court.
Civil court avare hogidare some suit.
The revenue authorities prima facie cannot have changed the revenue records entry after a lapse of decades.
No, so they
should have simply directed you to go before the civil court, get a declaration. No, sir.
So they themselves, they did not get any relief so far.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
ಆರ್ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅವರೇ ಪಿಟಿಷನರ್ ಸೂಟ್ಗಳು ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲ, ಈಗ ಆಸ್ ನಾವು ಏನಾಗಿದೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಬೇಕಾದ್ರೆ
WP number serial number 16, 17, 19 and 20.
ಅಲ್ಲ, ಒಂದೊಂದರಲ್ಲಿ ಒಂದೊಂದು ಇದೆ. So
in all these matters, the learned AGA takes notice for the revenue authorities and the state and the revenue authorities.
So even delay also.
Learned Counsel Shri E.M. Venkat Reddy has entered appearance for the contesting respondents. Namely, contesting respondent, namely
5.
ಏನು ಹೆಸರು? ಹೆಸರೇನು?
ಜಗದೀಶ್ ಪ್ರಸಾದ್ ಒಬ್ರಿಗೆ ಜಗದೀಶ್ ಪ್ರಸಾದ್ ಅಂತ
ಒಬ್ಬರಿಗೆ ಮಾತ್ರ
ಶ್ರೀ ಜಗದೀಶ್ ಪ್ರಸಾದ್.
ಬೇರೆಯವರು ನೋಟಿಸ್ ಬೇರೆಯವರು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
Notice to the other respondents. Issue notice to the other respondents in all these matters. Full stop. Next para. Learned Senior Counsel Shri Ashok Arnalli, appearing for the petitioners in all these matters, submits that the impugned orders passed by the Assistant Commissioner and the Deputy Commissioner directing entry of the names of the contesting respondent in the revenue records by setting aside a mutation entry made in the year
several decades, 75 below.
Made in the year 1975.
ಇಲ್ಲ ನಮ್ಮ ಲ್ಯಾಂಡ್ಸ್ ಗೆ ಸಂಬಂಧನೇ ಇಲ್ಲ ಇವು.
They are not is clearly without authority of law. Full stop. The Learned Senior Counsel has pointed out from the impugned order passed by the Assistant Commissioner that while allowing the amendment application filed at the hands of the appellant therein, that is Shri Jagdish Prasad, the objections filed to the amendment application is taken as the objections filed on behalf of the contesting respondents therein, impleading applications are allowed on the same day, and orders are passed without hearing the contesting respondents. Full stop. Delay is also condoned.
Delay, he says,
Without,
to be condoned.
Delay condoned.
No order is passed.
Delay condoned.
No specific order is passed on the ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿಲ್ಲ
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ. The Learned Senior Counsel further submits that no formal application for condonation of delay
ಅಲ್ಲ ಹಾಕಿಲ್ಲ ಅಂತ
was filed at the hands of Shri Jagdish Prasad, however, a single line order is passed by the Assistant Commissioner stating that the delay is deemed to have been condoned on the action of the contesting respondents. Full stop. Next para. There shall be an ad interim order of stay of the operation and execution of the impugned orders passed by the Assistant Commissioner and the Deputy Commissioner, until further order.
Even earlier, the High Court order has not been challenged. High Court, there is specific direction and
yes, sir. Yes, sir. We will consider.
The number 18, police protection also given merit.
Yes.
I have challenged the impugned order as annexure page number 9. The Deputy Commissioner. Page number 30.
Yes.
Under this
Grant certificate.
It is not a grant certificate, my lord. In fact, the land belonging to me has been reserved for the alleged public purpose of burial ground. It is a private land.
Allah, Annexure C. Annexure C is a grant certificate.
Annexure C is the grant certificate. Annexure A, Annexure B is the order, my lord. It is a page number 23. Relevant page is 25. Because by this order, page number 23, title copy article. It's an order passed
by the Deputy Commissioner on the appeal filed by me rejecting my application for regularizing 3 acres of regularizing the land.
What is Annexure C then?
Annexure C is the Sagawali issued. In the Annexure B, the court has directed 3 acres should be granted to me. Annexure C is the Sagawali cheat, where it is the Tahsildar has granted only 2 acres instead of 3 acres, contrary to the decision of the court. Therefore, I had filed an appeal, my lord, as per the Annexure B, my lord. ಅದು ತಪ್ಪಾಗಿ ನೀವು ಮಾಡಿದ್ದೀರಿ. ಪೇಜ್ ನಂಬರ್ 32. ಇದರಲ್ಲಿ 3 ಎಕರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದು 2 ಎಕರೆ ತಪ್ಪಾಗಿದೆ. ಡೆಪ್ಯೂಟಿ ಕೈಂಡ್ಲಿ ಕರೆಕ್ಟ್ ಇಟ್ ಅಂತ. The assistant commissioner by his order has directed the Tahsildar ಚಿಕ್ಕಬಳ್ಳಾಪುರ ನಂದಿ ಹೋಬಳಿ ಸೋನ್ಸೋ ರಂತೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡುವುದನ್ನು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೋಲಾರ ಜಿಲ್ಲೆಯ ಸೋನ್ಸೋ ಆದೇಶವನ್ನು ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆಗಳನ್ನು ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಿ ತನಿಖೆ ನಡೆಸಿ ಕಾನೂನಿನ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಜರುಗಿಸಲು ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರಕ್ಕೆ ಸೂಚಿಸಿದೆ. ತಹಸೀಲ್ದಾರ್ ಮೇಲೆ in fact your lordship may now turn to the impugned order as a connection.
So when that process is still underway, this impugned order has been passed.
In fact, the 3 acres again is the 3 acres grant agide. Again remaining 1 acre ge
when was that order passed by the deputy commissioner for reserving the land for
2012-2021? 2012-2021 last month madam.
Ellide Annexure F
2012-21 ಕ್ಕೆ ಈ ಆರ್ಡರ್ your lordship may kindly see ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಅಧೀನ ಅಧಿಕಾರಿಗಳ ವರದಿ ಹಾಗೂ ಕರ್ತವ್ಯದಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ ಕೊರಸ್ತಿಗ ನೂರರಲ್ಲಿ ಪಾಣಿಯಂತೆ ಒಟ್ಟು 1 ಎಕರೆ 33 ಗುಂಟೆ ಜಮೀನಿದ್ದು ಸರ್ಕಾರಿ ಹುಲ್ಲುಗಡ್ಡೆ ಕರಾರುಗಳಿಂದಾಗಿ ವರ್ಗೀಕರಣಗೊಂಡಿದೆ. ಈ ಕೂಡ ಸೂಕ್ತವಾದ 1 ಎಕರೆ 33 ಗುಂಟೆ ಜಮೀನನ್ನು ಗುರುತಿಸಿ ಪೂರ್ವತಿ ಗ್ರಾಮಸ್ಥರಿಗೆ ಸಾರ್ವಜನಿಕ ಸ್ಮಶಾನಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸುವ ಬಗ್ಗೆ ಮೋಜಿನಿಂದ ನಕ್ಷೆ ತಯಾರಿಸಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಪ್ರದೇಶದಲ್ಲಿ ಯಾರು ಅಕ್ರಮ ಸಕ್ರಿಯ ಮಾಡಿರುವುದಿಲ್ಲ ಮತ್ತು ನಮೂನೆ 50, 53, 57ರ ಅರ್ಜಿ ಬಾಕಿ ಇರುವುದಿಲ್ಲ. ಈ ಪ್ರದೇಶದ ಮೇಲೆ ಇದೆಲ್ಲ ಇಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಪ್ಯಾರ ಮೇಲ್ಕಂಡ ಅಂಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಾಗೂ ಕಟ್ಟಡದಲ್ಲಿನ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಇದನ್ನು ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶವಾಗಿರುವುದರಿಂದ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಸರ್ವೆ ನಂಬರ್ 100ರಲ್ಲಿ ಸರ್ವೆ ಸ್ಕೆಚ್ ನ ತೋರಿಸಿರುವಂತೆ 1 ಎಕರೆ 33 ಜಮೀನನ್ನು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಡಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ 1940 Yes. I will read section 71.
Yes.
No, 3 grant certificate is order.
That is why.
ಇಲ್ಲ ನಾನು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಯಾರು ಗೊತ್ತಿಲ್ಲ. even now I am in position, my lord. Even now I am in position. The order of the court, deputy commissioner prevails over the Sagawali cheat. Tahsildar cannot sit in over the order of the deputy commissioner.
That is why.
And refuse it to 2 acres.
That is why he had approached the assistant commissioner. Aito. Sari ne. Whether right or wrong, there was a direction given by the assistant commissioner directing the Tahsildar to verify and pass necessary orders. Correct.
Not prior to that.
2012 or 2021.
2021 ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. My lord, in that also ನಾನು ಒಟ್ಟು ಇರೋದೇ ಅದರಲ್ಲಿ 4 ಎಕರೆ 6 ಗುಂಟೆ. ನನಗೆ 3 ಗುಂಟೆ ಹೋದ್ರೆ ಇನ್ನು 1 ಎಕರೆ 33 ಗುಂಟೆ ರಿಸರ್ವ್ ಮಾಡ್ತಾರೆ. 1 ಎಕರೆ 33 ಗುಂಟೆ ಇಲ್ಲ, 4 ಎಕರೆ 6 ಗುಂಟೆನಲ್ಲಿ ನನಗೆ 3 ಎಕರೆ. In fact, remaining 1 acre ನಾನು unauthorized occupation 1970 ಇಂದ ಇದ್ದೀನಿ. Your lordship may now kindly turn to Annexure E, my lord. ಆ 1 ಎಕರೆಯನ್ನು ನಾನು
regularization goes application that was rejected. Against that, I filed an appeal. The last kindly see case number 28. This is an appeal filed by me rejecting my application for that 1 acre.
28 is again Annexure C.
Annexure E, 28, page number 28.
Yeah, Annexure C.
Each one.
33 then. Page number 33, Annexure E.
Sorry.
So
either an application for regularization of remaining 1 acre that was rejected, against which I have filed an appeal before the assistant commissioner. Assistant commissioner, second para. ಮೇನ್ ಮನೆಯಲ್ಲಿ ನಿರೂಪಿಸಿರುವಂತೆ ಚರ್ಚಾಸ್ಪದ ಜಮೀನಿನಲ್ಲಿ ವಾದಿಯವರು ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಇರುವುದಾಗಿಯೂ ಸದರಿ ಜಮೀನು ಕೃಷಿ ಯೋಗ್ಯವಲ್ಲದ ಜಮೀನಿಗೆ ಹೆಚ್ಚಿನ ಹಣ ಮತ್ತು ಶ್ರಮವನ್ನು ವಿವರಿಸಿ ಫಲವತ್ತಾದ ಜಮೀನನ್ನಾಗಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿಕೊಂಡು ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಇರುವುದಾಗಿ ಸದರಿ ಜಮೀನನ್ನ ಸಕ್ರಮೀಕರಣಕ್ಕಾಗಿ ನಿಗದಿತ ನಮೂನೆ 53ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿಕೊಂಡಿರುವುದಾಗಿ ತದನಂತರ ಪ್ರತಿವಾದಿಗಳು ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಸ್ವಾಧೀನತೆ ಪ್ರತಿಷ್ಠೆಯಾಗಿಸಿದ್ದಾರೆಂದು ನಮಗೆ ಸದರಿ ಜಮೀನು ಬೇರೆ ಯಾವುದೇ ಜಮೀನು ಇರುವುದಿಲ್ಲ ಎಂದು ಪ್ರತಿವಾದಿಗಳು ಹೊರಡಿಸಿರುವ ನಡೆಯುವುದನ್ನು ರದ್ದುಪಡಿಸಿ ವಿಧಿವಿಧಾನಗಳ ಅನ್ವಯ ನಮೂನೆ 53ರ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡಲು ತಹಸೀಲ್ದಾರ್ ಭೂ ಸಕ್ರಮಿ ಸಮಿತಿ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕುಗಳಿಗೆ ಸೂಕ್ತ ನಿರ್ದೇಶನ ನೀಡಲು ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಕೋರಿರುತ್ತಾರೆ. ರಿಗಾರ್ಡಿಂಗ್ 1 acre ರಿಮೈನಿಂಗ್ ಇದ್ದಲ್ಲಿ ವಾದಿಗಳು ಆದದ್ದು ಹಾಗೂ ಕಡತ ನಡವಳಿಕೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಅರ್ಜಿದಾರರು ಪ್ರಸ್ತಾವಿತ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕಿನಲ್ಲಿ ಹೋಬಳಿ ಗುಡವತಿ ಗ್ರಾಮದ ನೂರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನಿನ ಭೂ ಮಂಜೂರಾತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಜಮೀನನ್ನು ಮಂಜೂರು ಮಾಡಲಿಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ನಮೂನೆ 53ರ ಅರ್ಜಿ ಪ್ರತಿಯನ್ನು ತಿಳಿದು ಬಂದ ಆದ್ದರಿಂದ ಮೇಲೆ ಅಂಶಗಳು ಪರಿಶೀಲಿಸಿ ಕಲ್ಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ. ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಸದಸ್ಯರು 53 ಅರ್ಜಿಯ ಭೂಕಂದಾಯ 94 ಬಿ ಹಾಗೂ ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮ 4.5 ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ವಾದಿಯ ಪರ ಸ್ವಾಧೀನಾನುಭವ ಹೊಂದಿರುವ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ ಬಗ್ಗೆ ಸರ್ವೆ ಕ್ರಮದಿಂದ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದಾರೆಯೇ ಇಲ್ಲವೇ ಹಾಗೂ ವಾದಿಯವರು ಕ್ಲೇಮ್ ಮಾಡಿರುವ ಜಮೀನು ಈಗಾಗಲೇ ಬೇರೆಯವರಿಗೆ ಮಂಜೂರಾಗಿದೆಯೇ ಅಥವಾ ಇತರರು ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿದ್ದಾರೆಯೇ ಹಾಗೂ ಯಾವುದಾದರೂ ಸರ್ಕಾರಿ ಉದ್ದೇಶಕ್ಕೆ ಮಂಜೂರಿ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆಯೇ ಎಂಬುದರ ಬಗ್ಗೆ ಸ್ಥಳಕ್ಕೆ ನಡೆಸಿ ವಾಸ್ತವ ವಕೀಲರಿಗೆ ಪುನಃ ಭೂ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿಯ ಮುಂದೆ ಮಂಡಿಸಿ ವಾದಿಯವರ ನಮೂನೆ 53 ಅರ್ಜಿಯಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಇತ್ಯರ್ಥಪಡಿಸಲು ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿ ಭೂ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿ ತಾಲೂಕಿನವರಿಗೆ.
So it is clear that there was an application in form number 53 pending. ಎಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ? ಹಾ 17-18 ಅದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಯಾವ ರಿಜೆಕ್ಟ್ ಆಗಿ ಎಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ? There is no rejection order. The assistant commissioner has directed the Tahsildar. So how can the deputy commissioner say that there is no application pending in form number 53? Huh?
It's all right. Now matter has been amended to consider my application. Therefore, my application under 53 or 53 is pending. Then that is pending.
Yes. All right. Yes. Then at AGA takes notice for response number 1 to 3. Issue notice to response number 4 and 5. Then it comes for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. We stop. Next para. Learned counsel for the petitioner submits that in the order of the deputy commissioner dated 23/3/1973, in case number RA bracketly LND close 96 of 1972, where Sri Lakappa was the appellant. Bracket ಅಲ್ಲಿ husband of petitioner number 1 and father of petitioners number 2 to 5. Correct? Bracket close. Comma, the deputy commissioner passed an order directing the assistant commissioner to grant 3 acres of land in survey number 100 of Kuduvatti village, Nandi Hobli, Chikballapura Taluk to Sri Lakappa. Full stop. However, grant certificate was issued only in respect of 2 acres of land, contrary to the directions given by the deputy commissioner. Full stop. Form number 53 ಹಾಕಿದ್ಯಾರು?
Form number 53
ಲಕ್ಕಪ್ಪನೇ ಹಾಕಿದ್ರು. Late Sri Lakkappa thereafter filed an application in form number 53 seeking regularization of unauthorized occupation of 1 acre of land in survey number 100. Full stop. On the rejection of the said application by the committee for regularization of unauthorized occupation, ಯಾವಾಗ ಮಾಡಿರೋದು ಅದು? The petitioners herein approached the assistant commissioner in LND RA bracket ali C close 38/2021-22.
ಅಲ್ಲಲ್ಲ 180 annex G.
LND RA 180 of 2017-18. Stop. The deputy commissioner passed an order. Assistant commissioner passed an order dated 24/11/2021 directing the Tahsildar to find out by conducting a survey as to whether the petitioners were in unauthorized occupation of 1 acre of land as claimed in the application in form number 53. Full stop. In the meanwhile, and also to find out whether the same was reserved for any public purpose. Full stop. In the meanwhile, the deputy commissioner has passed the impugned order dated 20/12/2021 reserving 1 acre 33 guntas of land in survey number 100 for public burial ground. Stop. Next para. The learned counsel for the petitioner has made out a prima facie case for grant of interim relief. Full stop. When the application of the petitioner is pending consideration and till it reaches finality, the deputy commissioner could not have passed the impugned order reserving the said land for burial ground. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the operation and execution of the impugned order dated
20/12/2021
in 2012-2021 at annexure F, comma, until further order. ಹೆಂಗೆ ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತಾರೆ? ಇದು ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ ಈಗ, ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ ಈಗ.
99 ಇದೆ ಸ್ವಾಮಿ, 99 ರಿಸರ್ವ್ ಆಗಿದೆ, 99 ರಿಸರ್ವ್ ಆಗಿದೆ, ಮಶಾನ ಇದೆ. No, he could not.
No. You can't say it is he is satisfied because thereafter he filed an application. No. Illa. You will have to find out when that application was filed. Application in form number 53. 1 acre ge. Correct.
ಇದು 4 ಎಕರೆ 6 ಗುಂಟೆ, 3 ಎಕರೆ ನನಗಾಯ್ತು 100 ಇನ್ನು 1 ಎಕರೆ 6 ಗುಂಟೆ ಇತ್ತು. ಆ ಉಳಿದಿದ್ದು 1 ಎಕರೆಗೆ ನಾನು ಫಾರ್ಮ್ ನಂಬರ್ 53 ಹಾಕಿದ್ದೀನಿ. ಎಲ್ಲ ನಮಗೆ
He has also challenged that order, though belatedly he has also challenged that order. As per the directions of the deputy commissioner, 3 acres should have been granted. They have granted only 2 acres. Adunu challenge ಮಾಡಿದ್ದಾರೆ. Yes. ಇದೆ ಅಲ್ವೇನ್ರಿ? ಓ ಯಾವುದು ನೀವು
Applying for petition.
18. Yes.
Number 20.
Yes.
Applying for petitioner.
Yes.
Land in survey number 32 of Dandapalli village, Hoskote Taluku, has been granted to petitioner below. And before she was in unauthorized occupation, later by annexure A and B, the land is granted. Annexure A is the official memorandum, annexure B is the grant certificate below. Page number 9 and page number 11. Now what happened below? For granting for by the annexure G Milord. Page number 29. A survey has been made for allotting the land to Kurubara Sangha Milord.
Allah, what extent of land was granted to you?
2 acre 10 guntas Milord.
2 acre and 10 guntas.
Awesome.
ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ
ಏನು ನಾವು ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ, ಅದರಲ್ಲಿ ನನ್ನ ಲ್ಯಾಂಡ್ ಇದೆ ಮಿಲಾಡ್. ಅದರಲ್ಲಿ
the land that was granted you, ಅದು ಎನ್ಕ್ರೋಚ್ ಆಗುತ್ತಾ?
ಅದು ಅದರಲ್ಲಿ ಇನ್ಕ್ಲೂಡ್ ಆಗಿದೆ.
Who has prepared the sketch? When it was prepared? For what purpose?
Look, sir, for it is prepared because there is an application by the Kurubara Sangha for granting land. So on that basis, this sketch has been prepared by the third respondent, Taluk surveyor, Hoskote Taluk.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures from the learned AGA. Next para. The grievance of the petitioner is that although 2 acres and 10 guntas of land in survey number 32 of Dandapalli village, Kasba Hodli, Hoskote Taluk, was granted in favor of the petitioner, and grant certificate dated 19/8/1985 was issued in her favor, nevertheless, the third respondent, Taluka surveyor, has prepared the impugned survey sketch at annexure G
On the direction of the second respondent.
At the direction of the second respondent, Tahsildar, identifying a portion of lands in survey number 32 for the benefit of another
Kurubara Sangha.
Kurubara Sangha. So, it is alleged that as per the survey sketch, as per the impugned survey sketch, the lands identified forms part of the land granted in favor of the petitioner. Full stop. Next para. The second respondent, Tahsildar, is hereby directed to take note of the contentions raised by the petitioner and ensure that no orders are passed taking away the rights of the petitioner, comma, without due process of law. Full stop. The petitioner shall not be dispossessed during the pendency of this writ petition. Full stop. Yes.
But if serial number 34 is also same matter, my lord. Another allotee.
Same andre?
Same ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಅವ್ರಿಗೂ ಅದೇ ತರ ಆಗಿದೆ.
ಸರ್ವೆ ನಂಬರ್ 30 ಸೀರಿಯಲ್ ನಂಬರ್ 34
34 ಅದರಲ್ಲಿ ಅದು ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಆರ್ಡರ್ಸ್
ಅಲ್ಲಿ ಸೇಮ್ ಲ್ಯಾಂಡ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್.
ಲ್ಯಾಂಡ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ 1 acre 20 ಗುಂಟಾ ಸ್ವಾಮಿ. ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್. 1
acre 20 guntas. Grant dated? Grant certificate dated?
14th March 1984. Page number 12, 11, 12. 14th March 1984.
Ah, 14th of March 1984. Huh? Same order. ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು?
ಅದೇ ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿಲ್ಲ ಅಂತ
ಅನೆಕ್ಷರ್ ಆಯ್ತು. ಡೇಟ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ಓವರ್ ರೂಲ್ಡ್. Learned AGA takes notice for all the respondents. Same order. Yes. Huh?
Rebuild.
No?
Rebuild.
Chandranath Tariga.
For the petitioner, my lord, this is a petition by the owner of the land. My lord, there was a notice to the respondent, and pursuant to the notice, counsel appeared. Thereafter, the third respondent, who is the claimant, she died, and an application to bring LRs of the third respondent, those applications were filed, and
the file has been rebuilt.
Yes, my lord.
So today it has come up for acceptance of the copies of the writ petition.
Yes, my lord.
If the other side was here, we could have passed orders. Elli ivaru Prakash Hegde avaru.
Bishop.
Mr. Prakash Hegde.
Prakash Hegde for R3.
Bakali. This writ petition has been rebuilt since the papers were missing. Stop. Today, the matter is listed for acceptance of the copies of the writ petition, along with the annexures and IAs number 1 to 3 of 2000, furnished filed at the hands of the petitioner.
Yes, my lord.
Stop. Next para, matter is called out. There is no representation for respondent number 3, although respondent number 3 is
Lord, he was appearing.
He is represented by learned counsel Shri Prakash Hegde. Full stop. Next para. Release this matter on on 17th of February 2022. Full stop. If there is no representation for respond number 3 on the next date of hearing, comma, this court will proceed to pass appropriate orders.
Please, Miller. Please.
Our colleagues ಯಾರು ಇಲ್ವೇನ್ರಿ? ಆರ್ ಎಲ್ ಪಾಟೀಲ್ ಅವ್ರ ಕೊಲೀಗ್ಸ್ ಯಾರು ಇಲ್ವಾ? ಏನಾಗಿದೆ ಕೋರ್ಟ್ ನೋಟಿಸ್? Since learned counsel Shri R.L. Patil who was on record for the petitioners is no more, comma, the registry was directed to issue court notice to the petitioners, comma, with a order dated 23/2/2017. So, court notices issued to petitioners number 2 and 3. Huh? Connected matter. Yeah, connect ಆಯ್ತಿದು. ಕೊಟ್ಟಿದ್ದು. ಅದು R.L. ಪಾಟೀಲ್. ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಲಕ್ಷ್ಮೀ ನರಸಿಂಹಪ್ಪ ಅದನ್ನು ಸೇಮಾ? ಅದು ಸೇಮ್. ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಎಲ್ಲ ಏನ್ ಹೇಳ್ತಮ್ಮ?
Representations as dismissed, however, liberty is reserved to the
ಅದಕ್ಕೆ ಮುಂಚೆ
court notices issued to petitioners 2 and 3 assert. Notice sent to petitioner 1 is neither returned nor there is any representation for any of the petitioners.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಪರ ಮಾಡ್ಕೊಂಡು ಅದು ಹಂಗೆ ಇರ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಪರ ಮಾಡ್ಕೊಂಡು ಸಿಮಿಲರ್ಲಿ ಇನ್ WP ನಂಬರ್ ಅದು ದಟ್ ವಿಲ್ ಬಿ ಇನ್ WP ನಂಬರ್ 17994 of 2011. ಇದರಲ್ಲಿ ಸಿಮಿಲರ್ಲಿ ಇನ್ WP ನಂಬರ್ 17995 of 2011, comma, notice, court notice sent to petitioners number 1 and 2 are served, but notice sent to petitioner number 3. Huh? 3 to 5. Allah, notice not issued. That's all right. If it is not issued for want of PF, that's everybody. Court notice issued to both the petitioners are served, but they remain unrepresented. Full stop. Next para. Consequently, both these writ petitions stand dismissed. However, with liberty to the petitioners to move an application for restoration of the writ petition. Yes. Complaints of office objections based on IA number 1 of 2022. Learned counsel for respond number 5 submits that office objections raised on IA number 1 of 2022 shall be complied within a week's time. Full stop. Ordered accordingly. Interim order granted earlier stands extended to the next date of hearing. Anything?
26, my lord.
25.
I'm sorry, ma'am.
Typed copy to be furnished for all manuscript portions. ಏನಿದು?
Somewhere in the year 2020, said ordinance is not to be by notes of directed that we shall issue form number 10 pursuant to that order. We notice notes in the when considering notes the said aspect that the private notes itself had no jurisdiction to entertain notes an application and thereafter to pass on. In fact, notes in the year 1994 itself, the chairman of the land tribunal notes taken a dissenting view, stating that we don't have any jurisdiction and it cannot be notes considered. Despite
why no jurisdiction?
Because money is not spent under the Mysore notes.
Religious and charitable. It had to go before the deputy commissioner.
Yes. And another aspect is that the village itself notes was not notified as per notes section 1(4) of the Act. In respect of notes, a village is not notified under the Act. There is no jurisdiction notes conferred upon the land tribunal, even notes the deputy commissioner also. So now the order is passed, directing notes that we shall issue the form number 10. And that's the notes we have to focus on. Since it is an honest order and notes non-judice, it is not enforceable.
All right. We'll issue notice.
Please.
But ಈಗ ಈ ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ?
Private parties notes normally what happens is that notes the judicial authority
normally
the affected parties notes will be justifying the action.
Issue notice to response number 2 to 164. Yes.
Meanwhile, clearly stated for because otherwise it may result in failing contempt and thereafter not. Well, there is a direction that we should pay in terms of task every day. Not issuing.
But how see when was this order passed? ಮತ್ತೆ ನೀವು ಸಡನ್ ಆಗಿ ಬಂದ್ಬಿಟ್ಟು ಇವಾಗ ಸ್ಟೇ ಮಾಡ್ಬಿಡಿ ಅಂತಂದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? Anyway, you go and tell before the contempt court that we have filed a petition and notice has been ordered. No sir. It will be too much of an asking because
instead of 50 notes they are served at the bank is served. It's a state. Since it is an honest order, I am asking for that. It cannot be enforced also. Otherwise, it cannot be enforced.
All these parties are before the contempt court. They are not invited in contempt court. No, biಡಿ. Let us. Hangena radre you move an application. We'll see. Yes.
Lord, 26 I am appearing for contesting respondent.
Yes.
What question is involved?
By respondent number 3 in favor of respondent number 4, authority. The fact of the case, my lord, is that
it's come up for what today? Or what are you arguing?
Lord, it could be disposed of. A short point is involved.
Huh?
A short question is involved, my lord. It could be disposed of. If you allow.
Really, sir.
What happened was I raised an election dispute under the Cooperative Societies Act. On that day, when the election dispute was raised, joint registrar having power and he was who is entitled to hear the matter, he entertained the dispute. Later on, he was retired. New joint registrar was appointed. After his appointment, a very joint registrar, he himself was the returning officer who conducted the election. Therefore, the subsequent incumbent to the office of joint registrar, he referred the matter to the other joint registrar as an arbitrator, as provided under section 71B of the Act. That was now challenged by the petitioner, contending that he have no jurisdiction, it could be done only by the registrar. My law is very clear. A authority to
when that officer is the returning officer,
yes,
how can you insist that he has to hear the appeal?
My lord, my prayer is in my prayer. My prayer is that it is not to be heard by him. Law mandates, my lord, that the registrar of cooperative society has to hear the matter under section 71 of the Act. My lord, limited power is given under section 2A of the Act, where delegated legislation was given by the state government. State government has issued a notification. My lord, Annexure F, page 35, my lord. In that notification, my lord, specific power is given to specific officer with respect to specific cooperative society. In this case, what has happened, my lord, that this when the third respondent who had given power and he becomes disabled, at that point of time, my lord, he could have referred the matter to the registrar who has power to my lord, decide the case under section 71 of the Act.
Delegation agidiyalla.
Delegation is only with respect to society, my lord. Really see section 2A. Really for movement, my lord, Karnataka section 2A of the Karnataka Cooperative Society.
Sir, now you are aggrieved of what, sir?
I am aggrieved by the transfer order passed by the third respondent.
Where is that?
My lord, it is an annexure, my lord, E, page 34. He has exercised power under section 71(1)(b) of the Act, Karnataka Cooperative Societies Act, for transferring the matter to respondent number 4. My lord, he has also referred to notification dated 6/12/2016, which I have filed, my lord, as annexure F, page 35. Lord, section 71(1)(b).
The registrar on receipt of the reference of a dispute under section 70, transfer it for disposal to any person
who has been invested by the state government with powers in that behalf. But this power is given under section 2A of the Act. Section 2A of the Act. Appointment of registrar, additional registrar, joint registrar, deputy registrar, state representative. 2A, section 2A. The state government may appoint a person to be registrar of cooperative society. The state government may appoint any additional registrar of cooperative society, joint registrar of cooperative society. Can you see subsection 5? The state government may, by general or special order, confer on any person appointed as general additional registrar of cooperative society, joint registrar, deputy registrar, assistant registrar, either as officiating or other, all or any of the powers of the registrar under this Act. This section 70 or 71 power, which is granted to only registrar, exercising power under section 2A subsection 5. The notification was issued on 6/12/2016. The same is referred to in this transfer order also, and I have annexed it, Annexure F, page 35. In that, with respect to one joint registrar or additional registrar, with respect to one cooperative society or specific nature of cooperative society, power is granted. If he is not able to exercise power, then the general power is granted under the Act by the legislature to the registrar of cooperative society. He could have exercised that power. He cannot transfer it to some other delegated legislative authority, cannot further subdelegate it to another authority under the Act.
Also, we will direct the registrar to pass that order of transfer.
It may not be necessary for simple reasons. Your Lordship may kindly go to section 71, my lord, for a moment. And once a dispute is referred to the registrar, on receipt of the same, reference of a dispute under section 70, decide the dispute himself or transfer it for disposal to any person who has been invested by the state government powers in that behalf. C may kindly be refer it for the disposal to one arbitrator appointed by the registrar. My lord, every registrar can exercise the dual powers. One, he can exercise the power as a registrar. It is a original jurisdiction. Suppose, my lord, if any registrar, he can refer that matter as an arbitrator.
Sir, why are you stuck up with this one? Let the registrar pass an order, he'll also be happy. Why are you hell-bent on seeing that the orders passed by or the person to whom the joint registrar has transferred, he only should hear it?
Lord, if such being the case,
if they are not happy, let the registrar pass. If he passes the same order referring the matter to the same person, let him pass.
1 week.
What is that?
Let he can pass.
Why should you unnecessarily waste your time here like this?
He can pass an order within 1 week, my lord.
Yes, yes. Berkeley. So this matter is listed for orders, for rectification of the office objections raised on the statement of objections and memo for dispensation filed at the hands of respondent number 5, with the consent of the learned counsel, the matter is taken up for final disposal. Next para. The petitioner herein is aggrieved of the order of transfer passed by the fourth respondent, joint registrar of cooperative societies, appointing
Not appointing, referring the dispute to the
referring the dispute to be decided by
an arbitrator.
The arbitrator
as an arbitrator.
Petitioner herein is agreed. The order of transfer passed.
Transfer beda.
Referring the dispute to be decided by the arbitrator.
Who who is none other than Joint Registrar of Cooperative Societies.
That is fourth respondent.
Huh?
Fourth respondent. The third respondent has passed the order.
Order is passed by third respondent. Third respondent somebody who is none other than the fourth respondent.
No, R3 and R4 are different. R3 and R4 are different. R3 is the joint registrar.
Correct. Gottaitu. That I wonder. The petitioner seeks to raise a technical objection that the power of delegation provided under section 71(1)(b) is to the registrar of cooperative societies and not to the joint registrar of cooperative societies, to whom the power of the registrar to decide a dispute under section 70 to delegate it to the joint registrar of cooperative societies, deputy registrar of cooperative societies, and assistant registrar of cooperative societies in terms of a government order dated
6/12/2016.
6/12/2016.
6/12/2016. Full stop. Full stop. Next para. On hearing the learned counsel for the petitioner and learned senior counsel Shri M.R. Rajagopal for a new petitioner, a new respondent number
Now
5.
respondent number
For respondent number 5, comma, this court is of the considered opinion that instead of instead of making the parties to wait for this dispute to be resolved, comma, it would be in the interest of both the parties to direct the registrar to make use of his powers to delegate the matter or decide the matter in terms of section 71 70 bracket 1 bracket B na
71
section 71 of the act. Full stop. The learned counsels have accepted the suggestion made by this court. Full stop. Next para. Consequently, this writ petition stands disposed of while setting aside the impugned order dated 26/7/2021 at Annexure E and the consequent order
that is the notice issued by the fourth respondent.
And the consequent notice dated
3/8/2025.
3/8/2021 at Annexure G, comma, while directing the second respondent, registrar of cooperative societies, either to decide the matter himself or refer the matter to any other competent authority who is empowered to decide the issue in terms of the provisions of the Karnataka Cooperative Societies Act. Full stop. The registrar shall pass necessary orders referring the matter to any other authority or at any rate to decide the matter as expeditiously as possible and at any rate within a period of 2 months. 2 months agoda?
ಎವಿಡೆನ್ಸ್ ಕಮೆನ್ಸ್ ಆಗಿದೆ, 1 ತಿಂಗಳಲ್ಲೇ ಮುಗಿಸ್ಬೋದು. ನಮ್ದು ಡಿಸ್ಪ್ಯೂಟ್ ನಾವು ಎವಿಡೆನ್ಸ್
within a period of 6 weeks.
Very well.
From the date of receipt of a certified copy of this order. Yes. In Mikidala, complaints for office objection, you please comply with the objections. It will be listed for preliminary hearing.
Item 27, my lord. May I make a mention?
Serial number 20 is election matter.
Item 27, my lord.
Already similar matter.
28.
My lord, 27.
There is office objection is that I have.
We don't worry about that one, sir.
It
will be disposed of in terms of that order. Yes.
27, I am mentioning, my lord.
Because already we have the calendar of events. If the actually election should have been held, or that is on the 30th, that is the candidates have filed the nomination and all that. But any of the subsequent.
We have issued the directions that it should be conducted as expeditiously as possible, and that will be undertaken by the learned counsel who appears for the election authority. Yes.
Item 27, my lords, I am mentioning, my lord.
Because the board will.
Adalla gottaytu, sir. Yes.
Item 27, I am mentioning.
Yes, really.
My lords, it is an order, my lords, felling of the tree. My lord, there is only a minor objection that respond number 2, my lords, we are not shown as who represents, my lords, it is by secretary, my lords. It is a special order, it is posted. See, if it is listed in the orders list, I will not be able to. This has to come up for preliminary hearing, is it? My lord, it has to come up for preliminary fresh matter.
Serial number 27 list this matter on 14th of February.
Great.
Yes. All other matters which have been listed for complaints of office objections, you please comply it and it will be listed. If there is an interim order to be extended, you please mention it.
Serial number 56, all IAS, that is LR should bring on record, may kindly allowed in that.
Not now, sir. Not possible.
Court officer. Court officer. Court officer. Court officer. Court officer.
Court officer 230 sitting ಇದೆಯಲ್ವಾ?
Court officer sitting ಇದೆಯಾ 230 ಗೆ? Court officer ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Court officer. ನಾನು ಇನ್ನೊಬ್ಬ ಬೇಯಿಸ್ತೀನಿ. Court officer. Court officer. Court officer ಕೇಳಿಸ್ತಾ ಇದೆಯೇನ್ರಿ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಏನೇಳಿ ಸರ್?
ಈಗ 230 ಸಿಟ್ಟಿಂಗ್ ಕ್ಯಾನ್ಸಲ್ ಅಲ್ವಾ? ಇಲ್ಲಲ್ಲ?
ಹೌದು ಸರ್, ಕಮಿಟಿ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೇ ಸ್ಪೆಸಿಫಿಕ್ ಅರ್ಜೆಂಟ್
ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ 1 ವೀಕ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಪ್ರಿಲಿಮಿನರಿ ಬರುತ್ತೆ. ಕಂಪ್ಲೇಂಟ್ಸ್
ಇಲ್ಲ, ನಾನು ಐ ವಾಂಟೆಡ್ ಟು ಸೀಕ್ ಫಾರ್ 2 weeks. ಸ್ವಲ್ಪ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು. ಓಕೆ, ಮಚ್ ಅಬ್ಲಾಸ್ಟ್.